You applied to some RTI, it was BRTF did not consider it.
On instruction of the competent authority, combined alignment was prepared by the FTSA, the respondent number 9. As per the combined alignment prepared by the respondent number 9, FTSA, the combined alignment is submitted by both the consultant and on being instructions given by the higher authorities, competent authorities, the option 1A was Sue's.
No, please come to page number. There is no page, of course.
Option 1A was selected. It's because there was option 1A, 1B, 1C, and 2, 3. Out of that, option 1A was selected.
In this bunch, where is the option 1A?
Option 1A is given at alignment option 1,
Yes, page number 16 probably. There's a bunch given by FTSA and X3A. There are two bunches. Okay, there are two bunches.
yes, as I pointed out,
There page. Eight.
Hello, just to clarify that part, may I take your lordship's to the affidavit filed by the respondent department,
The
in affidavit, original affidavit,
Yes.
It is in page number 38A, as I pointed out, the survey was done.
No, your additional, that's in the IA or in
No,
the...
main affidavit, main affidavit. Page number 38A, affidavit filed by the respondent number 6, 7, 10, and 11. This is the final approved alignment after the submission of the bill verification report, as per the instructions of the competent authority, alternative A was selected,
Page number 38A.
my lord. Final, my lord, this is the final approved alignment by which, my lord, of course, my lord, admittedly, it is not clearly stated in the main affidavit, my lord. However, my lord, the copy, my lord, this, the approved alignment is annexed here with, my lord. Page number 38. My lord, intake point is Thalia project start point. And
Then
it touches almost to, my lord, the Earring village and alignment option to Tato, my lord. It is green portion, my lord, shown. And Tato, after, my lord, just right hand side, my lord, option alternative A1, alternative 2, alternative 3 is given, my lord. Out of this, my lord, alternatives, alternative 1A was selected, my lord. This is the final, my lord, approved alignment, my lord. After receipt of the, my lord, joint part survey report, my lord, after receipt of the, my lord, the technical inputs. No, my lord, another aspect, my lord. May I submit, my lord? At this stage, my lord, of course, my lord, after so many hearings, my lord, we, my lord, the time and again, my lord, came to, my lord, they discovered the certain documents. My lord, combined, my lord, the affidavit, detailed affidavit is, my lord, limited understanding is required to be filed as because, my lord, at the relevant point of time, when the first affidavit was filed, this was not brought to the notice of this honorable court as because this has took subsequently, my lord. And at that relevant point of time, my lord, I'm told that, my lord, the final DPR was also under preparation, my lord, because of which, my lord, the
Final?
entire thing is not, my lord, placed before this honorable court.
Yes, final.
Final DPR, my lord. During the pendency of, my lord, this PIL, my lord, as I'm told, my lord, the DPR was finally prepared. And at the relevant point of time, when the affidavit was filed at the first instance, my lord,
No,
this has
it's
not been
okay.
brought to
Since you are representing the department,
my lord.
you can record your submission. But that has to be on record. If you are making a submission that a final DPR has been prepared after submitting all these documents
My lord.
with regard to the option 1A road.
My lord, admittedly, my lord, if may I take your lordships to the paragraph 7, where, my lord, regarding optional 1A is referred to, my lord.
Paragraph 7.
Paragraph 7 of my affidavit, my lord.
Affidavit in opposition.
Affidavit, the main affidavit. On the last occasion, your lordship was asking for the, my lord, where is the approved, final approved alignment?
Page
Is that
number
really
4.
para 7, my lord?
Page 4.
Yes, ma'am.
Page 4.
Sorry, sir. My lord, para 11, my lord. Page 5, number 5. I'm reading, my lord. That with regards to the statement made in paragraph 7 and 8 of the FIL, the answering deponent states that the petitioner's statement is false because the physical verification report, the public consultation meeting, and the letter of acceptance and the contract agreement asked by the DC, Dapur is a white letter number so and so, dated 12 June 2023, copy enclosed for your ready reference as Appendix B, have already been forwarded to the DC. And the Dapur is a white letter number so and so, dated 8 August 2023. This is the matter of the copy. Number one, copy is on this aspect also, we have already examined. The final field verification report conducted by both the implementing agency along with the copy of the various alignment explored by the DPR consultant as per Annexure 2. The copy of the final consultation, public consultation meetings is enclosed Annexure 1. Copy of the final letter. I'll skip this part. Now, my lord, the letter which they have referred is, as I have already shown your lordship, at page number 38A, my lord. This is the final, my lord, approved alignment. So it touches from, my lord, the Thalia to Tato and
That
Tato.
Orange portion. Orange portion.
Orange portion. And regarding that justification, my lord, why the option 1A was, my lord, selected, there is a justification, comparative statement in, my lord, the all, my lord, aspect has been taken into.
Please come to page number 8 of the bunch today that you have given.
Page number 8, my lord.
That's the report of the FT, sir.
My lord.
Is it that road that which you have been approved?
My lord, I'm not following, my lord, this, my copy, my lord, this copy has been handed over to me just now, my lord.
No, it doesn't matter.
So therefore, it is also not paginated, my
So
lord.
you can take the help of your officers. This page number 8, FT, sir. This page number 8 of FT, sir. That once you have,
My lord.
there are two parts. One part is by the
Yes, my lord. Page number 8.
got it. There's a page number
Yes,
FT, sir. FT, sir.
Correct, my lord. 8.
This is the road you are talking about.
Option, my lord.
1A.
Option 1A.
Got it.
Page number 7, my lord.
Page
Yes,
number
ma'am. 8.
8.
Internal page number 8, ma'am. Yes, ma'am.
Got it.
Yes, ma'am.
Is it the road you are talking about? Option 1A.
My lord. Option 1A, the preferred alignment
Preferred.
which is proposed to be recommended. The alignment is all weather roads.
This is the road you are talking about.
My lord. This is the approval, final approval. As for instruction, madam. I will give you what. Admittedly, my lord, in the past instance, this has not been brought to the notice of reasonable cause. Even, my lord,
Required, you have submitted. Mr. Kato, can you tell us on which date the DPR was accepted? Or when it was accepted by the authority? Because earlier the road was approved by the MOT.
My lord.
The road was approved by the MOT and that's shown to us, right? From those communications. Thing is now that there was a process to place before the court and there was no DPR, nothing. Now, as directed by the court, the DPR have been placed. Now, with regard to one PA, the DPR that was submitted, when did you accept? When did you
My
finalize?
lord, admittedly, so far, my lord, we have not produced my lord, the copy of the DPR prepared by the my lord, department. My lord, exactly as I pointed out, the joint field verification was carried out by the
That we have seen. Field verification was carried out.
But
There is also.
that has been submitted to the BRO, madam. Accordingly, BRO forwarded it to the ministry, madam. And the ministry,
Yes, Mr. Sharma. It appears there was a DPR, there was a.
It
field
seems
verification.
everything has come out today.
No, no, it's fine. We'll pass on.
Now,
We'll pass
so
on.
only one aspect of the matter. If your losses are of the view, just one proposal. Losses of the view that I think substantially there has been compliance and lordship is not inclined to interfere. My only prayer would be, we had also filed representation before the authorities and the BRO that particular route as a second route may not be an alternative route, but
See,
second route will be considered. That aspect may also be looked into by them.
You have been moved up my with along. I was discussing with my brother.
Yes, person.
See, there's a new road
Yes.
where coming to Gopur side, from without touching Mission Sariali, Balipara, Jamuguri.
We came by that route.
Right.
Yes, Lordship.
Now, there was an existing road. Hardly the expenses would have been less if it had been widened,
Yes.
right? But what they have done, they have built another
So,
road.
That is creation of more roads.
No, difficult, but if you come, you have definitely from Kolia you have come to the new road.
Yes.
Hardly there is any villages, only the paddy fields are there,
Yes.
entire route, or tea gardens are there.
Yes, Lordship.
There are no houses, nothing.
As of now, there is nothing.
There is nothing,
Yes.
right? So why they have decided? So
Yes.
things are that it is the decision of the authorities concerned at certain point of time. It
No,
is
I-
their priority.
I understand that.
Right.
In fact, in the
How
technicalities
a
also, it's
read
difficult to
book-
enter.
Now, you had a point saying that earlier there was a road which
Yes.
they have to abandon because of the difficulties in the terrain.
Yes.
So this is also a terrain, a similar kind
No,
of
in
terrain.
that same route
So
they are
that
going.
might at a certain point of time after, because in that route after 12, 20 years, they have
12
abandoned.
years. Yes.
So
Lord.
this is also they might, and it is public cost. But thing is this, what we have seen the letter and the participation of the highest authority of the military operation, who suggested the reasons why this particular tough terrain is required. Do we have to interfere? These are the things which is in my mind, and that's also in a PIL.
As advocates, we can also understand.
Right. So to that extent, we'll pass a detailed order. Okay.
Yes, Lordship.
We'll pass
Only
it.
to that aspect that if an alternate route, not an alternate, an additional optional route can also be explored by them. That option, if it is kept open,
No, we'll make it.
that
we'll make
option,
it.
if
We'll make it.
tomorrow they think that more roads
And
can be
see,
created,
basically, in a PL, to what extent in a technicalities we can interfere? Because it is. up
I
to
understand. Since everything is now
No.
there, it's difficult for a RIT court to enter into those aspects. I understand that.
Okay.
But
We'll
only
pass-
that option may kindly be looked into
Sure.
also. Oblige, Your Lordship.
Pardon, Mr. A. Sharma, counsel appearing for the petitioners. Mr. Mr. Nawab, you are for 1, 2, or
For respond number 2, my lord.
you are for 2?
My lord, is there any observation made on 11:6, my lord? Because that time my friend he was absent, so I raised something, my lord. Is there any observation from the Honorable Court passed on 11:6, my lord?
11-6.
11:6. If there is any observation, that is okay. If there is no observation, my lord, I have nothing to say anything more.
Let us. No, there was an order passed earlier on 12th of October.
My lord,
That was the status quo order was passed, and which is still in force. And then you are
Because-
saying about 11-6.
11:6, my lord, if I correctly remember, I raised the maintainability of this PL, my lord.
Huh.
11:6.
Entire hearing is over now.
No, yeah,
You have raised the issue of
remember.
maintainability. We have raised the
Hearing may
issue.
be
of
over.
maintainability. That's right.
Yes, my lord.
You have raised it.
So manner, my lord, the PL has been filed. Your lordship may kindly see who is before your lordship, my lord. One is my lord, association, my lord, is a oriented beneficiary association, my lord, the Silent Valley. The another is my lord, Upshur, my lord, who is busy body, my lord. Now, my lord, yes, my lord. And
We'll consider it.
your
Your
lordship may
submission.
kindly consider also as per the High Court rules, my lord, 2011, whether they have complied with it or not, my lord. To
Will
tell
be-
you, my lord, they have bypassed the High Court rules, my lord. That's all, my lord.
But my lord, our NDPR was for my lord, the adjudication of the issues, my lord. Not on the, my lord, the merit of the technicalities, my lord. My lord, I am representing respondent number 4, 5, 6.
Just a minute, we're just noting down. D. Kambuk, Standing Council,
Land management.
Land Management Department for the respond number 1, 3, 1 and 3. Then Mr. R.H. Namam, Additional Advocate General for the respond number 2.
Yes.
Mr. M. Kartul, Learned Deputy SGI, DY for the respond number 4, 5, 6,
And newly
7,
newly implemented.
10,
No, my lord, not 8, 10 and 11, my lord, newly implemented respondent.
10 and 11 you are representing, though?
Yes, madam.
10 and 11. That is the Chief Engineer Project Oruna,
My lord.
10 and 11. Mr. You are Mr. K. Loya, Learned Counsel for the respondent number 8, and Mr. D. Lazi, Learned Counsel for the respondent number 8. Order is approved.
Obliged, Your Lordship.
Deeply obliged, my lord.
No representation on behalf of the petitioner or for. You are appearing for whom?
Respondent. 1, 4, 5, and 6.
In the IA.
I as well as in the retail.
And Mr. Z. Taraf. Learned Standing Counsel for the Road Welfare Department.
Yes,
Rural PWD or RWD?
RWD.
Okay, Rural Works Department. Respondent numbers, opposite party numbers, opposite party, public respondents. Number 1, all respondents,
Not all. 1, 4, 5, and 6.
1, 4, 5,
Five and
and
six.
6. Who is for the PWD? Government advocate is PWD? Yes. Call madam. She is busy in her mobile. She forgot. Ma'am, are you representing PWD? Are you representing PWD?
Yes, Lordship, government is appearing for this. Yeah.
Who is appearing for the PWD? You are appearing?
Yes.
Record her name.
Appearing for 1, 2, 3, and 7.
Huh?
1, 2, 3. and-
One is rural. Not you. You are PWD or RWD?
Yes, PW.
2, 2, 3.
1, 2, 3.
2, 3, and 7.
3 and 7.
Wait, নাম কি? দেখা করো, দেখো। Okay. List after 5 years. On the date by the registry. No representation on behalf of the appellant. Oblique applicant, oblique appellant, accused applicant, oblique appellant. Also, there is no representation from the state. Please, such and such for idea, I mean, they have to be fixed by the.
Some objection in respect of item number 21. My lord, item number 19, my learned friend appears, he files a repetition 93. 93 repetition has been filed. There he appears as a private respondent. In that case, we are the co-bidder, he challenging the terms and condition. There is an interim order, 115 my learned friend appears, 150. Same terms and condition has been put to challenge, there is an interim order. Now another writ petition filed by learned friend, 227, my learned friend Dr.
That is item number 21.
21. So there is interim order. So there are some affidavits filed, some rejoinder has to be filed, let it be completed, minor all this, and let it come after reopening of the court, my lord.
But when the regenders are yet to be filed.
Yes, yes.
Yes, in item, in all these three matters, regenders are yet to be filed.
Yes, some rejoinder.
Item 20 and 21.
20 and 20.
In item 20 and 21, regenders are to be filed.
Yes.
So item 20, you are appearing.
My lord, 21. Item 20 is his 21. Oh, sorry, 20.
You are appearing in 20. Tell us when you will file your regender.
No, we have to file it. We file it.
Oh, you are the petitioners.
No, we are the petitioners.
Yes.
There is an IA to which objection has been filed, to which we will file a rejoinder during the course of today.
You want to file regender in both the matters with regard to the IAs.
Yes, in that. Yes.
Can you tell us the respondent numbers? What you are the
Yes.
respondent numbers? in
I am
the-
respondent number 4 in item 19.
Yes,
And
there you have filed your regender.
Yes,
Now in item 20, you are the respondent number
7.
and in 21,
21, I am not yet a party. My IA to be impleted is pending.
had they filed any objections?
Yes, that is
Yeah.
filed today. It has been served today.
Whether all are connected matters?
All
All
connected.
the same,
Same.
terms and condition.
Item 19, 22, give the numbers. Along with the IAs. It is submitted by the council for the parties appearing in these matters that issues involved in these petitions are same and connected. In IAC 83 of 2024, arising out of WPC number 1152,024, next paragraph. The applicant is seeking time to file rejoinder. Now, which is the IA for implement?
93 and 94. That is an with item 21.
Okay. In 93, in IAC 93, 2024 and IAC 94 and 2024, the opposite parties have filed their objections pertaining to the implement of the applicants today, or you can bring the today first. Today file their objections. And the applicants are seeking some time to file their rejoinder. The respondent number such and such in ISA 83/2024 and the applicants in ISA 93/2024 and ISA 94/2024 shall file their rejoinder, if any, on or before 18th July, placed on 23rd of July.
Can be not 22nd.
22nd.
22nd is Monday. We are
Mon-
not fixing on Monday.
I'm sorry, my lord.
So that will be better.
And
22nd is Monday.
Monday is better for us because
We need to.
very difficult for the court. A bit accommodation, my lord, if it is 22nd.
We'll fix it on 22. Otherwise, which date? Otherwise, which date? If not on 22nd, then give us a answer because we have to
20
find out from the registry because in this week, large number of matters have been fixed on 22nd. So in that case, we will fix another date. Give us another date.
No, it's very difficult because there are interim orders being passed.
So
So
in
let
that
it be,
particular-
my lord, let it be on 22nd. We'll see it, my lord. Or your lordship, a slight accommodation we want from your lordship, my lord. Otherwise, I will not have insisted your lordship.
Difficulty is many matters have been fixed on 22nd. That's the reason.
Let it come on
22nd.
As per everybody, list on 22nd.
I am deeply obliged, man.
Okay.
Interim order passed. Interim orders.
Is it until further order?
No,
or
till then.
till the next date of listing of the matters, interim order passed earlier.
20 maybe हो गया.
And the connected writ petitions shall remain in force.
Till then, my lord, till then.
Next, till the next date of listing.
Much of it.
My lord, that further you will say file in IA, my lord.
Yes.
No issue. Not in lane petition.
No. Yes, Mr. Tagore.
I beg to mention at number 16, my lord. My lord, I have not yet received Paravan's comment from department, my lord. This matter list, my lord, after vacation, my lord.
Who is for the petition?
I am for the petition.
Heard Mr. P.D. Nayak, counsel appearing for the petitioner. And Mr. T. Tagum, standing counsel education for the respondents. On the prayer of Mr. Tagum, respondents in the education department are allowed to file their affidavit. And such affidavit shall be filed by the education department, respondent education department on or before 19th July. List on when, Mr. Nair?
Could it be 5th of August or 29th of July?
Okay, 29th of July. I'm filing such affidavit of opposition by the respondents in the education department. Petitioner shall file. It's he or she, his rejoinder, if any, on or before 25th of July. List on 29th July.
Deeply obliged.
There's an interim order.
The interim order passed earlier shall remain in force till the next date of listing of the matter.
Deeply obliged.
Yes, Mr. Ratan?
My lord, I beg to mention item 10, 11, and 22, my lord. We are yet to file our affidavits here.
They have taken on 1930. And they yet to file affidavit.
Yes.
That's okay.
Mr. Ratan, you are appearing for whom in these matters?
My lord, I'll,
He's
For the
appearing for
state.
deputy commissioner.
Deputy Commissioner,
Respond number
9.
9. And 11,
No, these are separate matters.
we know.
Ma-
In 11, Deputy Commissioner, which district?
Lower the bound valley. Item number 10.
Okay. And 11, Mr. Ratan, you are appearing for whom?
here also, the Deputy Commissioner, my lord.
Which
State and Deputy Commissioner, ma'am.
state and Deputy Commissioner? Okay, for the state.
In item 10, I'll appear for respondent number 6,
6.
Yes.
Is the Deputy Commissioner or for the state?
for Deputy Commissioner.
Okay. Lower Dibang Valley.
Yes.
And in item 11,
Deputy Commissioner Changla.
This is for 2, 4, 6 to 12.
2, 4, and 6 to 12.
Yes, madam.
State.
Yes, madam. State.
Item number 10 is a matter related to a payment of salvation. Let them file.
How much the amount they have paid?
They have got the amount, but then they are seeking for the payment of salvation. Under
True. Solution paid or not paid?
salvation not paid.
Assessed or not assessed?
Not assessed.
Under a land was taken over under
They was
which?
taken under section 10 of the June regulation.
Now see, Zoom Act doesn't says anything. It is only says the land acquisition has to be paid.
Yes, but there are division bench judgment and then a similar matter was also.
Okay, in the division bench judgment, what is the direction?
Direction is that it can be, the probation can be paid under the LARA Act,
Under the Land Acquisition Act or the 2013 Act?
2000.
The land was taken over when?
2014.
2014, notification was issued.
Sorry?
Notification for taking.
Notification of 38, 2014.
The remaining amount has been paid.
Remaining amount.
What about 11? What about 22? Mr. Ratan?
22, we are here. We're yet to file our affidavit, my lord.
Mr. Nair, what is the issue in 11 and 22?
Madam, 11 is about for taking
Yeah.
over our lands without any acquisition and in the forest, madam. That was an old issue, madam. It is our traditional land. There was no acquisition and they have established a reserve forest. Madam,
Is it
we
a
are
reserve forest?
seeking-
It's a reserve forest?
Sorry, madam.
Is it a reserve forest?
It is a reserve forest.
Notified reserve forest?
Notified. Madam, we are claiming our rights not on the land acquisition, but under the traditional forest dwellers. The scheduled tribe traditional forest dwellers. It is not a case on the land acquisition. But in 22, my lords, there was no, my lords, award even passed. Some amount of money was assessed in a meeting and paid. There was no assessment of land.
In 22?
22 and 23. 22 and 23 are connected.
In those two matters, what kind of land?
But not our land, my lord, it is our allotted land.
Allotted land.
My lord.
You are in occupation.
We were in occupation,
Land allotted by whom?
my lord, by the government. Oh, sorry, my lord, not allotted, possession. Land possession certificates were there, LPC land.
LPC was issued duly.
LPC was issued earlier, my lord, long time. They've taken over the land, my lord. There was a notification earlier under 1894, thereafter under 2014 or 2013. But my lord, there was no award passed. When the meeting was originally held, my lord, before the coming into force of 2013, my lord, they assessed the money.
Yes, sir. Item 10. Mr. Ratan Ladet. Government advocate appearing for, you are a government or additional advocate general?
Additional Advocate General.
Appearing for the state respondent number 6, Deputy Commissioner Long Level, prays for some time to file its affidavit to its counsel for the petitioners, Mr. Sunil Mock. Has no such objection. Prayer is accordingly allowed. The respondents shall file their affidavit in opposition if not filed on or before 23rd of July by serving copy within bracket smallest, no? Will not counsel for the petitioners without fail. List on 29th July. Same order. The other matter was fixed on
Yes,
29th.
Yes, madam. Thank you.
16 also. You write.
11,
11,
And-
10. 11 you'll write, Mr. Ratan. For respondent numbers 2, 4 and 6 to 12.
6 to 12.
Same order. That's the time such and such said this one they filed their affidavit on or before such and such. We are serving in the counsel for the petition, to which Mr. P. denied. Counsel for the petitioner has no objection. Petitioners has no objection. Such affidavit shall be filed by such and such. List on 29th. Similar order at 22 and 23. Mr. Ratan, you are appearing here in 22,
Here
23.
in item 22 for 2, 5, 8 and 9.
And in the 23,
23,
Mr. Nabam is here.
okay, Mr. Ratan for respondent number 2, 5, 8 and 9. in WPC 174/2024 and Mr. Arrears Nambam, learned additional advocate general this state. Mr. Nair, for which respondents, can you tell us?
It will
Okay,
be same, my lord.
we'll verify, we'll verify.
It will be the same, my lord.
Let's check it up.
My lord is 2, 5, 8 and 9, my lord.
Same respondent. 518.
Same, my lord.
Same order. They'll file their affidavit.
My lord, can I make a small request, my lord, adjustment subject to my friends, my lord? Can this item number 22 and 23 can be segregated, my lord?
These are
Each
different.
ones are little bit different, my lord. Little bit different. Because
Okay,
basically item number
you write
22 is,
separate orders. Don't tag it up. Don't tag it up. Write separate orders.
my lord.
Okay.
Okay, then, my lord. Deeply obliged.
Deeply.
May I please, your lordship? Lordship, I beg to mention item number 3, lordship. This matter is came up for motion, lordship.
23.
Sorry, sir, lordship. Item number 3, lordship.
Hmm.
I have been instructed by the client that this matter may be withdrawn, lordship. He does not want to pursue this matter anymore, lordship.
What do you want?
We want to withdraw it, lordship.
Want to withdraw?
Lordship.
What's your good name?
T. Garam, lordship.
On instruction of the petitioner, Sri Nangram Tani, his counsel, Mr.
T. Garam.
Raja Garam, on instruction. No, on instruction, he already did, no? Praise for, no, right, on instruction. Praise for, is not pressing this petition. To which the counsel for the respondents, state respondents have no objection. Who is appearing for the state? Anyone appearing for the state? Earlier, who appeared? Mr. Luang appeared. You appeared. Mr. L. Luang, additional one, senior government advocate. Appearing for the state respondents number 1 to 4 have no objection. Accordingly, this writ petition stands dismissed, being not pressed. The interim order of status quo passed earlier on 18/06/2024 accordingly stands vacated or recalled.
Deeply obliged.
Yes.
Hello, sir. So I beg to mention item number 28. My senior counsel is out of station. This matter may be listed after 2 weeks, madam.
You are appearing for whom?
Respondent.
Mr. Bangin? 2019 matters.
Yes, but I'm given to understand that someone from Guwahati appears on behalf of the IOC. Mr. Tabit told me that he has not come. They are appearing for a private respondents. I have a stay in my favor, Manoj.
Is there any stay order in
Yes,
your
my favor.
on the prayer of council, on the prayer of the council for the parties? Please, this matter. After 6 weeks on a date to be fixed by the registrar. For hearing. Okay. This interim order passed earlier shall remain in force until further order of the court.
May I
Obliged.
proceed? I like to mention item number 1.
Yes.
On behalf of Peter Puck, due to the medical problems, he is not attending today.
When do you want?
After 2 weeks,
On the prayer of the council for the petitioner. Please this matter. On 17 July. Yes.
Lordship, another items, item number 8. Same on behalf of Peter Puck.
8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8. 8 Where it has been listed today, any idea? 93, 93. I think so that matter. Let the matter reach. There are other councils. Let the matter reach.
My Lordship. Lordship, I beg to mention item number 6 on behalf of A. Prakash. Your Lordship, the conducting counsel, Mr. Prakash, is outstation counsel, so he could not appear today. Therefore, this matter may be fixed on 29th of July.
Is there any stay order in force?
No, Your Worship.
On the prayer of the council for the parties, list on 2907.
Much obliged.
Yes, kindly give your name, your good name. Yes, sir.
One of the WPC number 335. I would like to mention to be listed for tomorrow, if possible. WPC 335 of 2022. Last
For
time it-
tomorrow, for what? Orders or admission or what? You want it to be listed for tomorrow?
Yes, I pray for the listing of listing.
For admission orders or for what?
It was in, I think it was in orders,
Okay, tomorrow.
most of life.
Yeah, please, Lordship. Lordship, I beg to mention item number 12, Lordship, on behalf of Tijamon, Standing Council of INC, Lordship. Lordship, he is out of station, Lordship.
So fixed matters, item 12. We will not extend the interim order because on the last occasion, interim order was not extended. On the prayer of we cannot do that unless there is an application. On the last occasion, the order was not extended. How can it be possible? We cannot do it ante. How is the appropriate application? On the prayer of the council for the petition, matter is adjourned for 4 weeks.
Your Lordship, I'm not making any adjournment prayer, Your Lordship.
You are appearing for whom?
I'm voting it is the, it is the council who responded is making adjournment prayer. So I have to pray my, I think maybe continue, Your Lordship.
See, for that you file your application, because on last occasion, interim order was not extended.
Your Lordship, in the
Some-
last occasion, it was listed on Thursday, Your Lordship. Your
It was
Lordship,
taken time of what? There's an order.
Your Lordship,
Okay, let the matter reach, we'll see. In that case, we are not passing it off.
right. Item number 2.
Your Lordship, in this matter, we have sought condonation of delay, which is about 182 days, but due to the fact that two of the petitioners have expired. Your Lordship, the state wanted to file an counter affidavit, which for the last 2 dates have not been received, but I humbly ask myself, Your Lordship, that this court has been extremely generous, as has been the Supreme Court, in the matter of condonation of delay when it is not motivated by any negative or any motivated in any manner. Lordship, what could be more pressing than the death of the petitioners, that too in a remote place? I humbly request Your Lordship that the delay may be condoned, and the whole purpose of asking for condonation of delay is that we should not delay, but the process itself is now causing further delay.
Item 2 is well.
Item 2 is me, no?
No.
Item 2 is for this thing was 46. I just read item 2. No. I'm sorry, Your Lordship, it seems. Oh, I'm sorry. I feel because of this confusion. I'm sorry, Your Lordship.
I think.
There was an order in a caveat, right?
Yes.
Yes,
You
Lordship.
you appeared for the caveator.
Not I'm for the petitioner, Lordship. I'm for the petitioner, Lordship. In the last occasion, your Lordship has given a direction to file an appropriate application to implement the caveator as a respondent, Lordship.
Did you serve copy?
Yes, Lordship. Copy has been served.
May I please?
In the caveat, you write. Learned counsel for the caveator. Oh, on that day, caveat was discharged, I believe. It was discharged. By this application in the IU, right? The applicant, Mrs. Global Loyal Construction / caveator. Prayed for its implement as party respondent number 7 in the connected WPC number 234 AP 2024. Sri Pandan Testing and 21 others versus state of Arunachal Pradesh and 5 others, stating that in the earlier read petition, WPC number 269 AP 2023 preferred by the present petitioners. The applicant was party respondent number 7. And in the present petition also, The petitioner is a necessary party for proper adjudication of the case. Do you have any objection for improvement
No,
of the
no.
petition? Mr. T. Garam, counsel appearing for the petitioners, have no such objection for improvement of the petition, improvement of the applicant as party respondent number 7 in the present proceeding. It is also submitted by Mr. Garam, learned counsel for the petition. That copy of this petition has, along its annexes have already been served to Mr. Yasli, learned counsel for the. You are Mr.
HP Jamun.
H.K. Jamin, learned counsel for the applicant. In view of the above, the registry shall incorporate the applicant as party respondent number 7. The connected WPC number 234 AP 2024. And shall also reflect the name of Mr. 8K Jamal, learned counsel for the respondent number 7 in the cause list. In the connected WPC number. For their observation and direction, this interlocutory application stands allowed. In view of the order passed today, in the petition you write, such and such made as party respondent number 7 in the present proceeding. Mr. H.K. Jamu, learned counsel, represents the respondent number 7. Okay. Yes.
Lordship. Lordship, the dispute arises, Lordship, starts from.
Before that, isn't such? Yes. Yes,
Yes.
yes.
Lordship. The fact is, Lordship, the 3 villages, Lordship, 3 village possess a community land, Lordship. On 14/9/2021, when the first meeting was held at the conference hall of the ADC Unumda, Lordship, it was decided in that meeting, Lordship.
Yes.
Yes. It was decided on that meeting that the construction of the school should be at Saulat, that is the community land of that 3 villages, Lordship. And the condition of that, and the meeting, it was further decided in the meeting that all the 3 villages has to give their consensus for construction of the school, Lordship. And accordingly, when this matter was decided in the conference hall of the ADC Lumda, Lordship, thereafter what happened, Lordship, on 29/9/2021, NOC was issued, Lordship. NOC was issued from the Gaon Bura of the 3 villages, Lordship, stating that the consent has been obtained from all the villages, Lordship. And thereafter, Lordship, accordingly, Lordship, on 19/9/2022, Lordship, NIT was issued, Lordship, for the construction of the school, Lordship. That is the, and the NIT was allotted to the private respondent number 7, Lordship. And thereafter, Lordship, when this matter came to the knowledge of the innocent villagers, Lordship, that is the petitioner, Lordship, we have filed an appeal of memorandum to the ADC concern, stating that we have not given a consent, and the NOC which has been submitted by the Gaon Buras, Lordship, it has been obtained fraudulently, Lordship. That is when the first appeal has been submitted before the ADC, Lordship. The ADC did not consider the representation submitted by the petitioner, Lordship. And thereafter, again, on second representation, when we submitted the second representation, Lordship, the ADC, instead of resolve the matter, Lordship, he has conducted another meeting with the Gaon Buras, Lordship. In that meeting, Lordship, 35 acres of land, which was initially decided to hand it over for the construction of the school, Lordship, it was reduced to 25 acres, Lordship. But that 25 acres still comes within the within the domain of that three villages, possession of that three villages, Lordship. And later on, Lordship, when this entire matter, Lordship, could not be resolved by the ADC, Lordship, and our grievances has not been addressed by the ADC, Lordship, we approached this Honorable Court by filing a WPC 269 of 2023. And while this notice was issued, Lordship, status quo order was issued by this Honorable Court, Lordship. Now, Lordship will kindly come to the page number 209, Lordship. Oh, sorry, 109, Lordship. I'm sorry, Lordship.
Yes.
On 29/1/2024, Lordship, when this matter came up for consideration before this Honorable Court, Lordship, that is the WPC 269 of 2023, Lordship. This Honorable Court has been informed by the counsel for the respondent as well as the counsel for the petitioner that the representation which has been submitted before the ADC, Lordship, that is and a communication letter dated 19/5/2023, Lordship. It is under the active consideration of the Gaumburas, Lordship. Now, accordingly, Lordship, this Honorable Court has given a direction to dispose of the representation which has been submitted by the petitioner, Lordship. Thereafter, Lordship, on 31/1/2024, Lordship, ADC Lumla has issued a notice, Lordship, regarding the meeting of after the order passed by this Honorable Court, Lordship. In pursuant to that, Lordship, the order has been issued by the ADC to conduct a meeting among the villagers, Lordship. And in that, accordingly, Lordship, on 21/2/2024, Lordship, when the meeting was supposed to be conducted, Lordship, and as per the direction given by this Honorable Court, representation which are supposed to be disposed of according with the law. But instead of that, Lordship, the Gaumburas, they have conducted the meeting in a manner that voting process has been started, Lordship. They did not even look after the representation submitted by the petitioner, Lordship. Now, the voting process, when it started, Lordship, 117% were present in the meeting, Lordship. And out of that, Lordship, 96% who are the influencer of the Gaumburas, Lordship, they have voted for construction of the school, Lordship. And we have voted against them, Lordship. Now, our only grievances is there, Lordship. When the willingness certificate and NOC, which has been submitted initially by the Gaumburas, Lordship, it has been obtained fraudulently, Lordship. And when the entire matter could not be resolved by the ADC, Lordship, we have approached this Honorable Court. And when this Honorable Court has given a direction to dispose of the representation, instead of that, they have started for the voting process, Lordship. They were fully aware that we, being a minority, Lordship, our voice will be suppressed by them, Lordship. And accordingly, Lordship, the 1/3/2024, Lordship, ADC has, in pursuant to that voting process, Lordship, the ADC has issued a letter to the respondent number 7 for construction of the school, Lordship. Now the construction of the school is at the very initial stage, Lordship. Only the boundary walls has been erected, Lordship. So at this stage, Lordship, my humble prayer, Lordship, let the notice be issued.
Mr. Karam,
Lordship.
see, earlier status quo was vacated.
Lordship.
And then there was a direction from the court that it was placed before the court. The representations from these aggrieved petitioners of these three villages were pending before the concerned Gaumburas.
Lordship.
So there is a direction that the Gaumburas will consider the representations of the petitioners and pass appropriate orders.
Lordship.
Right? Now, the ADC Lungla subdivision of Tawang district.
Lordship.
Fixed 2nd February 2024 for the said meeting.
Lordship.
So that the representation of the aggrieved villagers can be considered and disposed of.
Lordship.
The petitioners of WPC number 2692023
Lordship.
were aware about the meeting on 2nd of February.
Lordship,
They appeared in that meeting,
Lordship,
during which the Gamburas of those three villages
Lordship,
did not take the decision individually and directed because it is the decision of the villagers.
Lordship,
Petitioners were present
Lordship,
and other villagers from those three villages also present.
Lordship,
And out of that, there was a voting process.
Lordship,
Accordingly, votes were cast
Lordship,
and majority votes were in favor of establishing the school at the present location.
Lordship,
And the petitioners' petitioners lost that decision
Lordship.
in front of the majority votes. Why do you want to say this is in a bad order? Because it is the villagers of the three villages who participated.
Lordship,
And during such process, the majority of the villagers cast their vote for establishment of the school.
Lordship,
And only the few voters, that is the petitioners,
Lordship.
objected regarding the establishment of the school. So it is the majority of the villagers who want that school in that area. Where is the illegality?
Now, Lordship, our only concern is that, Lordship, when right from the inception of when the decision was taken by the ADC.
So that is initially, yes, it was saying that a submission of the certificates or the acceptance by the three Gamburas was not in favor or was obtained fraudulently or by other means.
Lordship,
Now at this stage, when the villagers, majority villagers of the three villages want that school,
Lordship.
the minority view will not stand.
In Lordship, in order to facilitate my argument, Lordship, when the first meeting, 14/9/2021, when the first meeting was conducted,
See,
Lordship,
that was over after the order of the court, because
Lordship.
direction was given by the court that decision will be taken by the Gamburas pertaining to the memorandum or representation submitted by the present petitions.
Lordship,
So the status quo order was also vacated and everything was removed. And then accordingly, the ADC fixed the meeting on 2nd of February by its commission on 31st of January.
Lordship,
All have participated, villagers of the three villages, including the petitioners.
Lordship.
You have cast their vote, they have also cast their vote, and the majority decision is that for establishment of the school.
Lordship, when this matter came up before this honorable court on 29/1/2024, Lordship,
Hmm.
only on the submission made by the parties that the representation submitted by the villagers would be considered by the Gamburas, Lordship. It was on active consideration, Lordship.
See, Gamburas, the three Gamburas of the three villages may not have come to a decision.
Lordship,
So they have placed it before because it is the views of the villagers.
Lordship,
Gamburas are representative of the villages.
Lordship.
So the majority villagers have cast their vote in favor of the school.
Now, my lord, my grievances is that, Lordship, right from the beginning, Lordship, our voice has been suppressed by the villagers or either through the.
No, see, initially it was the fault of the villagers, assuming, because they have given the permission.
Lordship,
Representing the villagers, it is the three villagers, three Gamburas given their consent.
Lordship,
You are aggrieved by that consent.
Lordship,
Now, instead of those consents of the village, Gamburas, the Gamburas have decided, let the villagers decide.
Lordship.
That was very fair. Instead of their taking decision in favor of the villagers, they have left it open for the villagers to decide. And for that purpose, there was voting. And during voting, the majority have voted for the establishment of the school.
Gamburas, Lordship, they are aware of the fact that, Lordship, if they have to dispose of the representation, Lordship, according
See,
to law.
how they would have represented, how they would have disposed of the representation. Either they would have called a meeting for all the villagers.
Lordship,
Accordingly, meeting was called for. All of them has participated. There was no consensus decision. So accordingly, there was a voting. In the voting, majority voted for the school to be established.
At least, Lordship, To my humble understanding, Lordship.
See, there has to be some illegality. Where is that illegality to be established? Come tell us.
That's why, Lordship, the series of facts has to be understood.
That
first,
is
Lordship.
over after
Lordship.
the order of the court, last
Lord-
order of the
Lordship.
court, because it is your submission, you have placed it and accordingly you have accepted it. Did you challenge that order? Passed in WPC 269. You have not challenged.
No, Lordship, because we are the petitioner in that proceeding.
That's true.
Lordship.
So the representation that was pending before the Gaumburas
Lordship.
was to be disposed of.
Lordship.
And the representation was what? That the school should not be established. The consent should not have been allowed.
Lordship.
Consent should not have been issued by the Gaumburas. So Gaumburas has left it open to the villagers. There's no wrong in that.
For the general interest, Lordship.
Since there is no consensus between the parties, between the villagers, so it has left open for the villagers to vote. They have voted.
Lordship, at this stage, Lordship, in that case.
Why? Why should, see, first of all, you have to establish your own case for issuance of a notice.
No, Lordship, in that case, Lordship, without issuing a notice also, Lordship, this matter can be disposed of and at least the representation and grievances which has been raised by the petitioner.
And on the basis of your representation, decision was taken, the meeting was called for. How the villagers, how the Gaumburas would have decided? Only after having an information, having a consensus decision by the villagers. How would have they decided?
Lordship,
Tell us a procedure how the Gaumburas would have decided your representation. To hear you and to hear others. Right?
Lordship.
So they have heard both sides and that's why they have called for the, okay, you cast your vote and you see whether you need a school or don't need a school in this area.
But the direction, as per the direction of the court, Lordship.
True, that representation, that is why the representation was considered and they found that in the representation, there was no conscious decision. Some has objected, some has proposed. So they went for voting.
At least, Lordship, the Gaumbura should have, Lordship,
See, Gaumburas are the representatives of the villages.
Villages, Lordship.
So tell us.
So it's true that for the general interest of for construction of the school, we have no objection with that, Lordship. Now the only is that, Lordship, our voice has been suppressed from the beginning.
See, what a question of suppression of your voice. You got an opportunity. There's no suppression. You got the opportunity.
Lordship, when the meeting was called for by the Gaumburas, Lordship, in pursuance of the notice issued by the ADC, Lordship, we were never mentally prepared for the voting process, Lordship.
That is what your right. You have exercised your right. You wanted the school should not be there, but majority decision was that the school should be there. Then only minority villagers have objected for the school. The majority applied for, majority said, yes, you need a school. Where is the illegality? First of all, tell us to interfere with this decision. Where is the illegality? Holding of the election was bad in law or others? What? If it was bad in law, why? Since the Gaumburas could not come to a conscious decision, villagers did not come to a conscious decision, the election took place. During the voting, majority had opted for the school. And only a few doesn't want the school there. So, and it was in the community land. It is not in the land of anybody. It was a community land.
Lordship, as per my instruction, Lordship, the petitioner, they were not willing to even participate in the voting process, so that they were by force because of the they are being minority, Lordship.
See, basically, you should have, if you haven't participated. You have participated in the villages. There are two options. Majority for school and the minority, including you, have said no school. You know the fate, Mr. Terry. The passage full of this. Heard Mr. Taram, the Taram Council for the petitions. And Mr.
I appear for 3, 4 and 6.
Learned Additional Advocate General for the state. All respondent numbers.
3, 4 and 6.
3, 4, 6.
And 6.
Who is for the land management?
Mr. Kamduk, he has given a letter of absence today. Otherwise, my lord,
Necessary party.
And Mr. H.K. Jammu, learned counsel for the newly implemented Testament number 7. It was the detail order.
all right.
Development this model.
My lord, this is the relevant recruitment rule. My lord, may come to the page number 11 of the relevant recruitment rule, schedule 7. In schedule 7,
Just a minute.
schedule 7. Here the relevant recruitment criteria for the constables are given.
Page 11.
Oh, page number 13, my lord. The page number 13, point number 7. Not in the petition, my lord. In relevant recruitment rule, just now I have given.
Clause.
Page number 13, point number 7.
In page
Education-
13, there is no 7.
Your lordship may come to the schedule number 7, then. Schedule number 7.
Yes, schedule 7.
Yes.
Yes.
Yes, in schedule 7, the relevant recruitment rule is given. Relevant recruitment criteria.
What do you want to place it from here?
And your lordship, in point number 6, in the first page of the relevant recruitment rule, point number 6, the power to relax has been given. Power to relax, where the governor of Arunachal Pradesh is of opinion that if it is necessary or expedient so to do so, he may order by the reason to be recorded in writing in observing the procedure as prescribed under so and so, dated 6 March 2013, and in consultation with commission relax any of the provisions of these rules with respect to any class or category of the person. And your lordship, in point number 7, repeal and saving. In the second part, in the second paragraph of the point number 7, nothing in this rule shall affect reservation, relaxation of age limit and other concession required to be provided for Arunachal Pradesh scheduled tribes and other special categories of person in accordance with the order issued by the governor of Arunachal Pradesh from time to time in this regard. So, your lordship, it is explicitly mentioned in the relevant rule itself that the concession must be provided to the special categories. And this compassionate appointment come under very special category. And
see, there is nothing right here.
Your lordship may come to the page
You are
number
appearing for which post?
for constable, for petitioners are appearing for the constables, constable, head constable, and various other posts advertised on 8 June 2024. Your lordship may come to the annexure 1, page number 31. Your lordship, our main prayer was to quash the notice dated 08/06/2024, wherein these two new criteria has been added. And your lordship may come to the page number 38 also of the petition.
When this rule was published in the Gazette?
Your Lordship,
When this rule was published in the Gazette?
it was published on February 2023.
February
February 2023.
in the Gazette? Arunachal Pradesh Gazette. When?
Yes,
Do you have a Gazette notification?
this is the notification, Your Lordship. The one I have provided just now.
Where from you have got it? Is it available in the Arunachal Pradesh Gazette?
It is not yet available, Your Lordship.
This rule is supposed to come into force from the date of publication in the Arunachal Pradesh Gazette. This is a notification. We are asking you when this notification has been published in the Arunachal Pradesh Gazette.
Your Lordship, even if there is a recruitment rule, there is no relevancy in appointment of the compassionate ground. Because they are exempted from writing such examination.
Show us. Show us. Show us that provision in the compassionate appointment rules of the government of Arunachal Pradesh. Show us that notification of the government of compassionate appointment.
Your Lordship, published in the official Gazette of Arunachal Pradesh, dated 4 July 2022.
Do you have a
Just-
copy?
Yes, Your Lordship. Constable, for a constable. Your Lordship, this is the copy. 4 July, it is published, Your Lordship. And Your Lordship, this official Gazette is more or less same only.
No, where it is shown this, we want to see the compassionate appointment rules. Compassionate appointment rules of the state of Arunachal Pradesh.
My lord, this is the official Gazette. This is the recruitment rule of the concerned department. And compassionate ground is different.
It's annexure 2 in the writ petition.
Yes.
State has adopted lawsuit the central scheme lawsuit by this law, office memorandum. And scheme starts from page 36 onwards.
Where is that scheme now of the 2022?
It starts from page 36 onwards. Poem issued by the central government is at page 33 lawsuit, 33 and 34. And main scheme starts from page 36 onwards.
Please come to page number 37.
Page number 37. My lord, in page number 37,
Clause 5B.
clause 5B, it says that applicant for compassionate appointment should be eligible and suitable for the post in all respect under the provision of the relevant recruitment rule.
So how this suitability to be considered?
And my lord, I have showed you the relevant recruitment rule. Now, my lord may come to the page number 38, where exemptions are given. My lord, compassionate appointment are exempted from the observation of the following requirement. In capital A, subclause, small a, recruitment procedure without the agency of the staff selection, commission, or the employment exchange.
So in his
And
case,
my lord, directly, my lord may come to the point B of the relaxation. Point number B of the relaxation. In exceptional circumstances, government may consider recruitment persons not immediately meeting the minimum educational standard. Government may engage them as trainees who will be given the regular pay bands and grade pay only on acquiring the minimum qualification prescribed under the recruitment rule. Your Lordship, this shows that even the OM says that, explicitly say that relaxation must be given. And the recruitment rule also says that the relaxation must be given. So department has no jurisdiction to impose such criteria, such stringent criteria on the compassionate appointment, compassionate candidates, Your Lordship. Because the main objective of the compassionate candidate is not to test their knowledge and their efficiency. It is to address their financial distress and destituteness, Your Lordship. So, Your Lordship, the notice dated 0806 is totally violative of all these conditions of recruitment rule and of the OM of this compassionate appointment also, Your Lordship.
do you have the eligibility for appointment? Do you fulfill the eligibility or not?
Your Lordship, there are many petitioners. There are 50 petitioners.
We are asking for that, whether the petitioners are eligible.
Yes, they are eligible, Your Lordship.
What is the criteria for eligibility?
Criteria for eligibility, Your Lordship,
Because
they must education qualification class 10 pass or from equivalent recognized board. Other essential qualification.
What are the requirements as per the recruitment rules? What are the eligibility for the recruitment rules?
They should be between 18 to 22 years.
And
in direct recruitment rule, not in on the compassionate.
Fine. What are the other eligibilities?
And they should be education qualification should be minimum. They should pass class 10th standard.
Now, just tell us, can anyone be appointed as assistant sub-inspector?
Not assistant sub-inspector, as constable.
Only as constable?
Yes.
So you will be applicable only for the constable?
Yes.
Okay. Let us see the recruitment rules for constable.
It is given under Schedule 7, my lord.
Schedule 7?
Yes. My lord, this is a prima facie case, my lord.
Please come to page number 12 that you have given.
Yes. Page number 12 of the petition, my lord.
Serial number 7.
Yes, my lord.
You fulfill all
These are the eligibility.
Serial number 7, education and other qualification required for direct recruitment, my lord, not on compassionate recruitment.
Even for compassionate appointment, you have to have these qualifications, clause 7.
My lord, that is what this OM says, that in exceptional circumstances, government may consider recruiting person not immediately meeting the minimum education.
See,
educational
you
standard.
want to become a constable.
Yes, madam.
Now you do not have a finger. Or you have certain probability with locomotor disability, which you cannot hold a arm. Can you be appointed as a compassionate appointment in the constable post?
No, physical standards should be,
That is why.
yeah,
please
that,
come.
that should be the criteria.
You have to, that is the reason you must have the eligibility.
Yes,
Do you fulfill all the eligibility criteria?
physical standard should be there, but physical efficiency and
That
this,
is what we are asking you.
yes.
Kindly read clause 7. Page 12. Do
Yes.
you fulfill clause 7 criteria?
Yes, yes, my lord.
You are sure?
Yes.
Okay. Now you do not want to participate in the
Physical efficiency test and written examination.
Okay.
It is not that I do not want to participate, but it is violative to the all the recruitment rules and the OM, my lord.
Now read clause 10.
Lordship, just this clause 7 lordship, part 2 and 3 lordship are yet to be done lordship. Lordship will find in clause 7 lordship education qualification, then lordship physical standard and then physical efficiency test lordship. So for this 2 and 3 is concerned, physical standard and physical efficiency test is fixed tomorrow only lordship. Is yet to be conducted.
Now we'll come to that.
Yes.
Now,
The lordship has put a query whether he is qualified on this clause or not lordship.
now clause 10. Clause 10.
Clause 10 lordship.
Page 13, page 12.
Lordship, kindly, lordship may use this one. Because there are lordship five categories of lordship recruitment rules lordship.
No, we have seen that eligibility. In that particular page 12, we want to read you clause 10.
No, so 20.
Clause 10, there are 7 you have just read.
23.
7 is related to education and other qualification required for direct recruits.
23.
Page 12 you have with your hand.
Lordship, here lordship 5 recruitment rules lordship. If lordship come to the last, the paper I take lordship. This is for the recruitment rules of the constable lordship. The last one.
Yes. Yes. Same thing.
Lordship.
Constable, civil aviation, police, right?
Correct lordship.
Civil police. Now in the clause 7, these are the educational and other eligibility.
Correct lordship.
Then clause 10.
10 is lordship method of recruitment lordship.
Method of recruitment, your lordship, 100% by direct recruitment. It talks for the direct recruitment, but your lordship,
So is there any 5% quota made for this direct recruitment or no?
yes,
5% is there lordship.
is there.
Your
5% is
5% is there. So that
Yeah.
is 5% of the total sanction post.
Yeah.
So during this recruitment process,
Lordship.
how many vacancies are there for compassionate appointment? Have you assessed that? In your advertisement, have you mentioned?
Lordship 35.
My lord,
You are required to mention that this number of vacancies only for 5% quota. If already the constable posts are above the 5% quota filled up through the compassionate appointment.
Yellow say in our notice laws, in advertisement, it has been mentioned laws. At page 31. Which is the impugned order in this writ petition lawsuit?
31.
31.
Yes. Yes.
Lawsuit, this is general information to all the applicants applied for compassionate ground in honorable person and so. That as on date, the clear vacancy is 35 various posts under compassionate ground in honorable and so. The categories lawsuit head constable in civil two post lawsuit.
Head constable is a promotional post. How can you fill up that post by compassionate appointment?
My lord, that is up to the department, my lord.
A head constable is a promotional post.
Lawsuit.
The provision itself shows the recruitment rules placed before us. February 2023, head constable is available at page 8. Head constable, page 7. 100% by promotion. Page 7. Page 7 of the bonds given by the petitioner. Method of recruitment, whether by direct, against that 100% by promotion. Then head constable, empty driver.
That means your
Civil police, 100% by promotion. Arunachal Pradesh battalion, again 100% by promotion. Then head constable, IRBN, 100% by promotion.
A lawsuit may come to this recruitment rule dated lawsuit 4th July 2022. 4th July 2022. It's I have orange marked one lawsuit.
You are following 2023 or 2022 rules?
This 2022 rules. 2022 rules.
23 rules not yet been published in the Gazette.
No, this is for lawsuit, head constable telecom lawsuit. Head constable telecom lawsuit.
Okay.
Can I come to the internal page? Internal page is not given lawsuit.
Okay, tell us the schedule. Tell us the schedule.
Schedule 6 lawsuit.
Yes.
Lawsuit will find
Schedule 6.
Schedule 6 lawsuit. Head constable telecom.
Schedule 6.
6 lawsuit. The advertised post is a head constable telecom lawsuit. If lawsuit come down to the close 7 and 10 lawsuit. It's 100% by
head constable
telecom lawsuit. Here lawsuit, if lawsuit come to the close 10 lawsuit, lawsuit will find lawsuit 100% by direct recruitment. It's a direct recruitment lawsuit.
Yes.
In telecom lawsuit.
How many posts are there?
2 posts only there.
How many percent of the compassionate appointment can be appointed out of 2?
Lawsuit?
Compassionate appointment?
No, out of total is saying lawsuit, 2 has been worked out as of today, 2 vacancies are there lawsuit.
2 vacancies are there.
Yeah.
For that, how many compassionate appointment can be made?
How many candidates can
be accommodated under compassionate quota?
Only 2. Because post vacancies are 2 only lawsuit.
This advertisement at page 131.
Lawsuit.
All posts are for compassionate appointment.
All are
Yes,
for
yes.
compassionate appointment.
Okay.
All posts are for compassionate.
In various category, head constable, telecom constable, pen, burglar.
Your grievance by what? What is your grievance?
Grievance is that your lordship, the department has added 2 new criteria.
SOAS.
That is PET and written examination.
Yes. to us? Where?
In page number 2. Your
Page
Lordship,
number?
2 of the petition. The matter.
Which page?
Or your Lordship may come to the page number 31. Page number 31, annexure 1.
Hmm. Yes.
My lord, may come to the third para.
Hmm.
Third para. The applicants are directed to produce all the original documents with succession certificate, death certificate, class 10 pass certificate, educational qualification, PRC, ST, income certificate, and other relevant documents before on board 26/6/2024 at 0700 hour at PTC Banardewa. The date of PST/PET has been fixed on 26/06/2024 at PTC Banardewa. And for those qualifying PST and PST/PET, the date of written examination has been fixed for 30/6/2024.
Okay.
So this kind of criteria was never added before.
Okay.
My lord, this is in complete violation of the recruitment rule and the OM itself. Department has no such jurisdiction to introduce such kind of criteria, my lord, according to OM and the recruitment rule for the compassionate appointment.
What's your good name?
D name, my lord.
Counsel for the petitioners. And Mr. Judge. You are appearing as?
I'm for respondent number 1 and 2, both.
1 and 2.
1 and 2. For all the respondents.
1 and 2.
Yes.
My lord, pending the disposal of instant petition, your lordship would please to pass.
When is the advertisement made? When the advertisement was made?
Page 31.
Okay. The state government. Don't write state government. The Director General of Police on 08/06/2024 issued a notice intimating all concerned that altogether 35 vacancies, out of which 2 for head constable, T means telecom,
Close. Yes, telecom.
28 post of constables, right? 2 post of constables within bracket band / burglar, and 3 post of constable within bracket driver are available under compassionate ground in Arunachal Pradesh Police. Specifying further that As per the existing government office memorandum, applicants for compassionate appointment should be eligible and suitable for the posts in all respects under the provision of the relevant recruitment rules. RR will be capital recruitment rules. By the said notice dated 08/06/2024, it was also notified that 05/06/2024 is the shall be the cutoff date, and no new application will be entertained for the ongoing recruitment under compassionate ground in Arunachal Pradesh Police. By the said notice, the respondent's father notified that the applicants, along with their original documents like succession certificate, death certificate, class 10 pass certificate, educational qualification certificate, age group certificate, permanent residence certificate, scheduled tribe certificate, income certificate, and other relevant documents should place before the board on 26/06/2024 at 0700 hours at PTC Kandadeva, and that the date of physical standard test oblique physical efficiency test have been fixed on 26/06/2024 at PTC Bandadeva. Or you can write Police Training Center, in bracket PTC, then next you will write PTC. And for those qualifying PST/PET, the date of written examination has been fixed on 30/06/2024. The respondents also notified that the list of applicants with remarks have all been uploaded in Arunachal Pradesh Police website, and the applicants who have been disqualified by the board been shown in red color, and those shown disqualified by the board, and those shown in red color are not qualified for PST/PET, and their candidates have been rejected by the board. The remaining applicants have been directed to report at PTC Bandadeva on 26/06/2024 with comfortable PT dress for PST/PET under compassionate ground recruitment. Petitioners herein have been qualified to appear before DPTC on 26/06/2024 for their PST/PET. for their necessary consideration under the compassionate appointment. But the petitioners are aggrieved with the specific observation made in the said impugn notice number PHQ/PER, that is -189/2022 dated 08/06/2024, whereby the respondent authorities, i.e. the Director General of Police, notified that the candidates for compassionate appointment in Arunachal Pradesh Police as advertised, on being qualified in their PST/PET, should also appear in the written examination fixed on 30/06/2024, which is in violation of the provisions of the, where is that memorandum? Government memorandum accepting the central government, our government memorandum, office memorandum
Page 32.
dated 080, office memorandum of the state government, Arunachal Pradesh, in the Department of Administrative Reforms dated 08/04/2023, accepting the provisions of the scheme of compassionate appointment dated 02/08/2022, issued by the Government of India in the Ministry of Personnel, Public Grievances and Pensions. The said office memorandum dated 02/08/2022 of the Government of India and the Ministry of Personnel, Public Grievances and Pensions. Annexed to this writ petition, at clause 5 relating to eligibility, though provides that dash italicizing, applicant for compassionate appointment shall be eligible and suitable for the post in all respects under the provisions of the relevant recruitment rules, again RR capital. But clause 6 within bracket capital A, that relates to exemptions, stipulates that at page 32-38. So that just marked it in by blue. Put it. The petitioners have also placed before the court that being candidates of our compassionate appointment, they are not required to appear any such written examination but the respondent authorities in the Home Department of the state, particularly the Director General of Police, while issuing the impugn notice dated 006/2024, categorically observed that such candidates for compassionate appointment qualified in the PET of the PST and the PET should appear in the written examination on 30/06/2024. Hence, this petition. issue notice. Returnable by, yes, you want to make any submission?
Here, Lordship, also, if Lordship is granting interim or
Have to,
Lordship. So for physical test is concerned also, did come.
for PSTPT, you are not
Okay.
obstructing,
Then,
only for the written exam.
loss.
PSTPT have to be there.
Yeah, because it's a
That
part
is
of
the part of the
qualification.
rules.
So,
Come just slide on. The provisions of the relevant recruitment rules for appointment to the head constable telecom, you have just said someone, Schedule 7, you said. Head constable telecom, ELCM. Then constable at Schedule 7, 6. At Schedule 6. Constable at Schedule 6. Provides for at Schedule 6 clause previously have been head constable telecom. No? There you're right. Where is head constable telecom? Just there in which page? 2022, right?
yes, yes. I have played the orange one.
Head constable telecom.
Schedule 6,
Schedule 6.
head constable telecom laws. The RR of
Clause 7. And for constable again for Schedule 6, clause 7. Provides for requisite educational and other qualification, including physical standards and physical efficiency test, with eye vision and medical fitness tests. Next look. The selected candidates for the post of head constable, constable within bracket band oblique burglar, constable within bracket driver, for compassionate appointment as notified by the input notification dated input notice dated 08/06/2024. The respondent shall proceed with the PST and the PET test. However, in the written examination or selected or qualified PST/PET candidates for compassionate appointment qualified in the PST/PET test. They stayed till the returnable date. Before that, you should notice returnable by 18 July. Petitioner shall take steps for submission notice in the respondent number 1P2 by during the course of the day, submitting such and such along with the annexes to Mr. Such and such, offering necessary acknowledgement from him in that regard. The respondents number 1 and 2 shall file its affidavit in the matter on or before 16th July. Submitting copy of the Mr. Such and such counsel for the petition. List accordingly. We go ahead with the PST and PET. Close. But not to proceed with the written examination. The results of the constables, result of the candidates for the post of head constable in bracket P, constables such as 4 groups are then shall be subject to the outcome of the Who is appearing? Mr. Tarak, you are appearing? You are appearing for the respondents?
Yes. Respondent 1 to 6.
Yes, you have received the representation on the petition.
Yes, there is representatives.
There is representation.
Let it be representation we dispose of.
No, no, that's what,
Secretary will verify whether grievance is genuine or not. I think there is. Chief engineer.
page number 63. Page number 63.
Page 63.
22.6.
Yes.
Just
Then,
read.
the result of evaluation part on the bid shall be made public on e-procurement system, following which there will be period of 5 working days during which any bidder may submit complaint which shall be considered for resolution before opening part 2 of the bids.
So
it was open, it was uploaded on 16th. 16, then
there are 3 or 4 such representations you have received on 18th. First of all, you have received on 18th. Page number
First representation by the page 137 on
That
7th
was-
June, immediately after uploading.
no, it was received by on 18th June only. It was on 17th of June. It was received on 18th June. Then
Yes,
the
ma'am.
next 9 at page 152.
chief engineer.
That was received also on 18th June. Page number 152.
Yes.
Then the last page 167.
167, ma'am, yes.
That was received on 28th of June.
Yeah.
So you are aware that the authorities concerned in the chief office of the chief engineer received this.
No, I have no instruction.
Get the instruction.
Yes.
Because these are sealed.
Yes.
We'll dispose it or we'll not keep it.
Yes. Then
Get the instruction now, will pass within 10-15 minutes.
Okay.
To come back with the instruction. These are the things the office of the chief engineer PMGOS received.
yes, yes.
That's all. Then you have to comply with 22.6. Get back the instruction and pass the order.
Ma'am.
Next.
May I present?
Just a minute. Yes, you want to change your date of birth from 64 to
Your Lordship,
66.
on the last occasion, this honorable court was making query in regard to annexure 1, page number 23 of the counter affidavit filed by the respondent. Your Lordship. In this regard, I must say, Your Lordship, this court has rightly pointed out this document. Your Lordship, this document is a typed copy, and there is a, Your Lordship, this is objection with this document, Your Lordship. In this document, the year is also mentioned 1976. However, the petitioner was passed only in the year 1979, Your Lordship. I may be allowed to file one additional affidavit bringing record that
Just tell us, show us your high school pass certificate. You have passed from which board?
that's why, Your Lordship,
Show us.
I need to file additional affidavit, Your Lordship.
That we will do it later. First of all, show us what is the basis of your claim for alteration of your date of birth from 1964 to 1966. And tell us on which date you have made your application before the authority.
Your Lordship, as per my petition, Your Lordship, I have not annexed my year of passing matriculation or higher secondary. Your
Now,
Lordship.
who
I have-
has given the date of your birth in your entry point of time?
It is been annexed.
Petitioner gave or somebody else gave it?
The document has been annexed by your respondent, Your Lordship.
No, just tell us. That is why we are asking you, because you want to change your date of birth from 1964 to 1966.
Yes, sir.
Now, you have entered your date of birth as 1964 on basis of what?
Basis of the, Your Lordship, when I was entering the higher secondary examination form, Your Lordship, there was an inadvertent mistake from my side, Your Lordship, as my father was out of his station and my mother is a illiterate person.
You have given your date of birth on what was the basis of giving you? Was there any certificate from school?
Yes,
any-
Your Lordship, I have annexed the documents, Your Lordship.
Which is that?
Page 52, ma'am. Date of birth and page 52.
Page 52.
Yes, sir, page 50 of the writ petition, Your Lordship.
Page 52 of the refutation. Yes.
Translation is page 53, Your Lordship.
What is your date of birth?
But actually,
As per this certificate, just tell us. As per this certificate.
31 August 1966. Your Lordship.
Okay. When did you receive this certificate? What is the date of issuance of this certificate?
It is shown as 3/8/2021, Your Lordship. Earlier, it was submitted before the authority with original document.
No. That is the reason we are asking you. Your date of birth is 31st of August 1966.
Yes, Your Lordship.
As per the authority, as per this certificate.
Yes, Your Lordship.
This has been issued by whom? This certificate, birth certificate was issued by whom?
Record of birth register of Nagar Palika Gola, district Lakhimpur Kheri.
Issued on which date?
It is written as 11/2/1992, Your Lordship. That stamp.
After how many years? After how many years?
26 years.
Now, as per the Registration Act regarding the date of birth and date, what is the procedure to be followed?
I have no idea.
You should, you are a lawyer, you are representing the council. You must know. Born in 1966, obtain your birth certificate on 11th of February 1992. After how many years?
It's almost like 26 years.
Is it possible? Is it possible? Under which provision of law you can take out a birth certificate after 26 years? So was the law. By that time, in the 1992 date of birth, the registration of birth and date already came into force in India. So was the provisions. So was the provisions. That's why we want to know from you.
Your Lordship, this matter may be adjourned. In the
No.
meantime, I will file my additional affidavit.
That's
And
not the thing. We can always adjourn, but thing is this, you have to first establish your case. Then we'll adjourn. We'll adjourn it, first establish your case. See, you have to, the petitioner must establish his case first. After under which provisions of law he could obtain such certificate, date of birth certificate in the year 1992. Anyway, when did you join service? Which date you have joined your service?
on 5 March 1990, Your Lordship.
5th of March 1990.
Yes, Your Lordship.
Okay. When your service was confirmed?
I have not annexed the document, Your Lordship.
When did you pass your matriculation examination?
In the year 1979.
You passed your matriculation in the year 1979.
Yes, when I was 13 years.
13 years. Okay. Have you corrected your school certificate? Matriculation certificate?
No, Your Lordship.
What was the basis for your entry of date of birth in your office record? Is that the matriculation certificate?
Yes, it is the matriculation certificate.
Unless you correct it, under which provision of law your date of birth can be corrected? In one hand, your matriculation certificate as your date of birth of 1964 will continue, right? You have
Yes.
not corrected it.
Yes, Your Lord.
On the other hand, you want to correct your date of birth in your service record as 1966 on the basis of a birth certificate that you have obtained in the year 1992.
Yes.
Is it possible? Just think, rationally think, forget as a legal. Is it possible? Your entire service record is on the basis of your matriculation certificate,
Yes. it is.
wherein your date of birth was given sometimes in the year 1964. Unless you correct your date of birth in the certificate, your matriculation certificate, is it possible to correct your date of birth in your office record? Because your base is in the matriculation certificate. Is it possible or not? Tell us. Is it possible? One hand, you will have a date of birth of 1964 as per the school certificate, matriculation certificate issued by the concerned board. On the other hand, your employer is required to correct your date of birth as 1966 on the basis of your birth certificate issued in the year 1992. Is it possible?
I could have approached before the authority
Which authority?
just after the passing of my degree also. But at that time, I was not financially sound person. to
Doesn't
make some
matter.
correct-
You are
It
not
will take
required
some-
for, you don't have to pay any thing for sending your date of birth.
When he made the inquiries for the correction in his date,
Would you know how many years you are required to change your date of birth? You can apply for changing your date of birth in the concerned board.
as per the amendment made in this writ petition, Your
We
Lordship.
are asking you, you have passed out from UP board.
Yes, Your Lord.
What is the time period within which you can change your date of birth? Any correction to be made in the date of birth, in the name of your parents, your place of birth can be corrected in the school examination, that is a matriculation certificate or higher secondary certificate, within how many years?
No idea.
Then
Your Lordship-
how the court will help you? If the lawyer doesn't have no idea, forget the petitioner.
Your Lordship, today I was here to just make an adjournment, pray for adjournment, Your Lordship. I need to file one additional affidavit bringing.
Your additional affidavit will not do any help. First of all, what is the time period to change your date of birth in a school examination? It is matriculation examination or higher secondary examination. Mr. Tagum, you are appearing in education department, right? In the state of Arunachal Pradesh, who is the authority to issuing matriculation certificate or higher secondary pass certificate?
Matriculation, it is the CBSE manner. CBSE, they will.
And higher secondary council, is there any state council? All these schools in the state of Arunachal Pradesh is under CBSE. I don't think so.
The CBSE man.
All schools are under CBSE.
Class 10 and 12, CBSE.
Okay. So Mr. Katu will be here. Within how many years you can correct?
At the past instance, as per the OM, it is given that at the past instances, it has to be correct.
It has to be corrected within 3 years. Within 3 years. After 3 years, you cannot correct. And there is a lengthy provision. You have to issue your, you have to do it in your, any such nationalized, any such newspaper, national newspaper. One national newspaper, one state newspaper. Publication has to be there within a 3 periods time. Now, every board who conducts matriculation examination or higher secondary examination have its own rules. As per their own rules also, either at a relevant point of time, what is the procedure, you do not know, but normally it is 3 years. Within 3 years, you are required to correct. After 3 years, you cannot correct. You can go through any judgments of the Honorable Apex Court or the Guwahati High Court, you'll see no permission was granted for correction of date of birth. If the record reflects that the date of birth was on the basis in the record, service record is on the basis of matriculation certificate. Then at first, the matriculation certificate has to be corrected. Have you corrected your matriculation certificate?
No.
You said no. Then how can your date of birth can be corrected in your service book?
Your Lordship, I mean, annex the date of birth certificate.
That certificate you have
They-
obtained in the year 1992 after
But-
26
but
years.
what-
Is it possible?
Your
That is why we are asking you. Is it possible to obtain the birth certificate after 26 years?
Your Lordship, on next day, I will come up with all these answers, Your Lordship.
Today's result and next day's result will be the same. Only the petitioner will be in
Your Lordship, just
artificial
a week time may be given,
support.
so that I will prepare my case again, Your Lordship.
See, you have been already communicated, right? So what else remains?
Yes, it is communicated, but not in accordance with the
See, that
guidelines.
is the reason you have admitted the fact that your date of birth entry in your service book is for your matriculation certificate. We are asking you whether you have corrected your matriculation certificate. You said no. Then unless you correct your matriculation certificate, how your date of birth can be corrected in your service book?
In terms of this certificate.
Is it possible? Did you place your birth certificate before the authority at the time of entry in the service book?
No, Your Lordship.
Then
At the time, Your
it
Lordship.
can be procured. That birth certificate been procured even from Pandukans. It's possible.
Whether it was possible or not, on that, yes, Your Lordship, I will make some research. Your Lordship. Just
You
adjournment.
have to first see. The petitioner has to establish his case first. Right? Come to page number 54, 53.
Yes,
Right? It's a
Yes.
translated document. Also, you can read, if you can read Hindi at page 52, you can read it. So, on the right-hand side at the top, the certificate was issued under which name? Under which act?
Issued under section 12/17 of registration of birth in that act 1969.
So, this particular act shows in which period you can obtain such birth certificate. Whether after 26 years you can obtain a birth certificate or not, you will know from that act and the rules framed here under. Just tell us one thing. Do you want an inquiry
Yes, Your Lordship, I'm ready for that, Your Lordship.
regarding issuance of this certificate?
Yes, Your Lordship.
Think over 100 times.
No, Your Lordship, I have.
See the act. See the act. Come back tomorrow. See the act, 1969 act, whether it is possible or not. See the act. Where is your appointment order?
Appointment order, Your Lordship, Annex 4, Your Lordship, page number 44, Your Lordship.
You have passed BTech
Yes, your lordship.
or what? What was your education qualification? What was your educational qualification?
I'm a BTech holder. Your lordship.
BTech holder. You produce your higher
B
secondary.
B civil. Your lordship.
Okay.
Bachelor in engineering.
Okay. Produce your matriculation certificate and higher secondary pass certificate tomorrow. Obtain it fax. Obtain it in WhatsApp.
Your lordship, I may be allowed to throw additional affidavit. Give
That
me
will
some
still
time, your
clear.
lordship. At
Produce
least.
it. Show us in your WhatsApp and print it out.
I
Produce
think
your WhatsApp matriculation and higher secondary pass certificate.
I have already, your lordship, printed out.
Hmm?
I have printed out, your lordship. It is with me, your lordship.
It is with you.
Yes, your
You
lordship.
have your higher secondary.
Both plus 10 and 12.
Yes, Mr. Kato. Do you think further time should be given to the petition?
My lord. Even a copy of IA is not furnished to me.
Hmm?
Copy of IA, my lord. Today, the matter is also listed along with one IA.
Hmm.
The copy is also not furnished to me, man. Even I have not seen what is the exact period of that IA, man. Otherwise, my lord, as per our affidavit, my lord, as per the settled position.
Clear, settle law.
Settled law, man.
Unless you correct your date of birth in your matriculation
By-
documentation, the basis on which you are.
Yes, ma'am.
That's clear.
By change of, my lord, the age, they should not be rendered, my lord, ineligible for appearing in the first standard, 10th standard, 12th standard, my lord. That is settled position. if it is changed, the year is changed, my lord, he will be rendered ineligible to appear in the first standard. 1964 to 66, 66 to 64. 2 years difference now. Then it will goes to my lord, the will render him ineligible in all examination.
Okay, since you have not furnished the IA to Mr. Forte, we are allowing time, otherwise we'd have dismissed it.
Your Lordship, I have already placed the copy to the advocate clerks. Your Lordship. Without that entry, this petition cannot be filed, Your Lordship. They have
So have you
received
made
on
copy?
behalf of my senior.
So have you an extra copy?
I'll do, Your Lordship.
Under prayer of the counsel for the petitioner. List after 6 weeks on a date to be fixed by the registrar.
Your Lordship, 6 weeks will be
He's already retired, right?
not retired. He will be retiring on 31st August, Your Lordship.
31st of August.
Yes, Your Lordship.
Yeah. 23rd July.
Your Lordship.
Develop.
Item number 8.
Yes.
My lordship, senior is absent, so 2 weeks may be given. Senior is absent due to the medical problem.
These are the opportunities. Senior is absent, you argue?
No, no, sir. No.
Spread to argue.
On behalf of T. Taba.
What is the matter about?
Yeah.
What's your good name?
VCO.
You're appearing for the petitioner?
Yes.
On 19, it was fixed for today.
Have you filed reply to the affidavit of the respondent number 4? Deputy Commissioner Kradadi District. Have you filed? No. Yes, ma'am. Pursuant to the order of the court, the respondent number 4 the Deputy Commissioner Palin of KRA DWADA district filed its affidavit in March 2024, disputing the claims made by the petitioner stating that a joint inspection was made over the land of the petitioner by the board members on 19/05/2022. And recorded the statement of the concerned Gaunburas, head Gaunburas, and Gram Panchayat members. The petitioner has not filed any rejoinder to the affidavit of the respondent number 4. More particularly, the disputes raised by the said respondent with regard to the claim of the petitioner. On the prayer of the petitioner, matter be listed after 4 weeks on the date to be fixed by the registry.
Item number 5. My lord, the representation dated 17/6 was received by the office on 18th at around 11:22. So by 11, financial bid was already opened on 18th. Now,
Just tell us one thing. When did you I don't think so. Page number 134.
134. Yes, which financial evaluation, then 136. Last part, recommendation.
On which date?
This is 16/6. It was recommended.
12/6.
It was signed on 12 and notified for
Yes, it was signed on
public view on 16,
16.
my lord. Down below, digital signs.
digital sign. The part of it should be open at office of the chief engineer on 18 June.
After notifying at least 5
16
days,
June. 16 June.
16 June, my lord, notified on 16 June. And 5 days start from after 16, my lord, after notifying. Within that 5 days, any complaint can be made. Before entertaining, consider the complaint.
It was rightly assessed. See, page 136 is very clear.
Yes.
5 days from 12, 17, right? So 18 was the date fixed for opening of the
Yeah.
financial bill.
Yes.
But you have not notified.
Yes, that's was.
You have not notified. And
Yes,
5
yes.
days from the notification as per 22.6. So you did not comply with the provisions of 22.6.
Yes.
So what order should be passed now?
Since his representation is there, to scrutiny that
Now what will happen?
if he
What? If you do not comply with the provisions, what is the outcome? Tell us. That is what we wanted to know from you.
My lord, only my
Jagum Learned Counsel appearing for the petition. And Mr. Z. Tarak, Standing Counsel,
for RW.
Rural Road Development Agency or for the Rural Welfare Department.
Rural Work Department.
Respondent numbers 1.
1 to 6.
You are also representing Rural Road Development Agency, Arunachal Pradesh.
Yes.
Arda.
Okay. You are representing ARDA,
It's under
Standing Council, Rural Welfare Department, as well as Arunachal Rural Road Development Agency. Representing all the official respondents number 1 to 6. Pursuant to an NIT dated 26/02/2024, issued by the Executive Engineer RWD Ying Kyong, relating to construction of roads under Vibrant Resilience Program, put in bracket VBP. From Ninging Village, NINGGING village to Tango, TENGGO.
LO 26, my lord.
Hmm?
LO 26, Neging Blaze number.
LO 2026 dash Ningo, Ningo village. And its maintenance for 5 years. The petitioner, along with others, submitted its bids. The bid valuation committee in the RWD Pasikat Circle. I do not RWD. You don't write Pasikat. On 12/06 2024 recommended the respondent number
7 and 8.
7 and 8. Who is 9?
9, my lord, the 8 has never participated, my lord. The person who has, the firm who has not participated, against his favor, the recommendation has been made. And 9 is the person, my lord, they have submitted EMD and all, my lord.
System consensus possible. Recommended respondent number 7 and 8 as technically responsive with us. Found qualified and eligible for opening of Part 2 dash financial bids, and found the petitioner to be non-responsive. The said bid evaluation report oblique technical bid evaluation report dash part 1 oblique technical bid was uploaded in the concerned website of the RWD on 16/06/2024. The petitioner on 17/06/2024, 18/06/2024, and 20/06/2024 submitted its representation before the chief engineer within bracket PMGSY ARRDA RWD ARRDA, RWD. As his representations noted above have not been noted above, submitted as per the provisions of clause 22.6 of the bid documents, the petitioner filed this petition. On being inquired, Mr. Tarak, learned counsel appearing, standing counsel appearing for the respondents herein, submitted that the concerned board have already opened the financial bids of the technically responsive bidders, that of respondent number 7 and 8 on 18/06/2024. In that regard, Mr. Tarak placed the bid evaluation, relevant bid evaluation report dated 12/06/2024, Annexer 4 to district petition, wherein the concerned board indicated that financial bids will be opened on 18/06/2024 in the office of the chief engineer RWD at Itanagar. Mr. Chagum, counsel appearing for the petitioner, placing the provisions of clause, place the provisions of clause 22.6 of the SBD, IBD of the instruction bidders relating to the impugned NIT dated 26/02/2024 pertaining to bid opening and evaluation and clause 22.6 of said bid opening and evaluation stipulates as follows, page number 63. 63 and 64. It is already spotted. Italy has correct. From the reading of said clause 22.6 of the IBD relating to NIT dated 26 impune NIT dated 26/02/2024, it can be seen that a period of 5 working days have been provided to the bidders from the date on which the bids have been made public on e-procurement system to submit complaint to be considered for resolution before opening part 2 of the bid, i.e. the financial bid. In the case in hand, apparently the bid evaluation report part 1, i.e. the technical bid of the bidders pursuant to the NIT dated 26/02/2024 involved in this writ petition was notified in the website of the respondent authorities on 16/06/2024. Annex 4, page number 134-136, the writ petition. Whereas the respondent authorities opened the financial bids of the responsive bids respond number 7 and 8 within 2 days from such publishing of the bid evaluation report part 1 of technical bid report in the concerned website. Which discloses the violation of provisions of clause 22.6 of the IBD. Issue notice returnable by July 18th. Opening of the financial bid on 18/06/2024 pursuant to the NIT of the respondent numbers 7 and 8 pursuant to the impune NIT dated 26/02/2024 in violation of the provisions of clause 22.6 of the IVD shall be subject to the outcome of, by the respondents, shall be subject to the outcome of this writ petition. The petitioner shall requisite extra copies of such and such along with the annexes appended to Mr. Tara by tomorrow, 25/06/2024, obtaining necessary acknowledgement from him in that regard. Let's start already.
My lord, may I pray, my lord, instead of subject to outcome, my lord, because
Now,
they may
let them-
proceed on,
already been mentioned, it has been in violation.
my lord,
If thereafter day goes, automatically it goes. They're aware, they have violated.
my lord. Only, my lord.
No point of staying.
My lord,
Let them
only-
go ahead, let them have that strength.
my lord,
It is their own IBD.
my lord.
And if they want to violate and proceed with, they know the consequences.
My lord, if it can be, not to finalize, my lord.
We will not say anything. How they can go ahead violating the IBD? That much, let them go ahead if they have the strength in violation of their own provisions. Court is there to help you.
Publish.
Let them be trapped in their own legs by that way. Why should you pass the stay order? Let them see. You just find out. It is mentioned in the order in violation of the provisions of clause 22.6.
My lord, correctly observed.
That's what, let them proceed. If they have the guts and the strength in provisions of law.
Only my
nothing
lord,
else.
my lord, gross illegality they have committed, my lord.
Sufficient.
Farm who has not even participated.
That is different.
That is different.
Whatever is that, forget that. That is, consider your
Representation, my
documentary. They have violated, you could have passed that order, easy to pass that order.
my lord.
But they have their own violated, it is their own idea. No? Yes. Yes.
My lord, here petitioners,
Hmm.
three petitioners, challenging the impugned order dated 19/4/2022, where the responding authority
Hmm.
gave issued superannuation
Hmm.
retirement order by the responding authority
Hmm.
by basing all the 1962 notification
Hmm.
prior to during NEPA period. One guideline is there.
Hmm.
On the basing of that guideline, the petitioner's service has been released. So, in pendency of this writ petition,
Now, just tell us,
RTI
this decision of above 45 years to
yes,
superannuate,
yes.
where is that order?
Page number 22, annexure 1.
Huh?
Page number 22 in my writ petition, annexure 1.
Page number 22,
Yes.
annexure 1. Where is it?
Uh, Government of Arunachal Pradesh, Office of the Deputy Commissioner, Karadare District, Palin. Order dated 19 April 2022. Page number 22.
Page number 22.
Yes.
22. Just a minute.
Writ petition.
No. This 45 years. On the basis of which provision?
Basis of their one provision during the time of NEPA, So, and that is annexed in my
This is an affidavit of opposition of the respondent number 2.
yes, that is submitted by the affidavit in opposition filed by the respondent authority.
Okay. Now
Page number 12.
that you have seen, Deputy Commissioner Kradadi has.
Yes, yes.
Okay. Now this notification of NEPA,
I claim this no more exist. And in pendency of this writ petition, I obtained RTI document from Chief Secretary, Government of Arunachal Pradesh, where clarified that we have adopted FR, fundamental right, fundamental rules, clause ABC. And their clarification clearly written that we have no such separate rules for ALC. I filed additional affidavit and bring the report before the Honorable Court. My Lord, kindly
see,
peruse my additional affidavit. It will more clarify.
has it been adopted by the state of Arunachal Pradesh?
Yes, Manoj.
There is adoption.
We are under this rule.
No, that is true. That is why this notification issued by NEPA during the course of NEPA. Has it been adopted by the state of Arunachal Pradesh?
Kindly see page number 19, Manoj.
19 of your affidavit of the respondent number 2. 19.
Yes, Manoj. Point number 28, Manoj. This issue with the concurrence of the Ministry of Finance, DA division with.
Page number 28.
No, 19, Manoj.
Page number 19.
Yes, Manoj.
Clause 28.
Yes, Manoj. This issue with the concurrence of the Ministry of Finance. Concurrence in the sense it's an agreement.
This is when?
In
26th of January to December 2002.
yes, Manoj. Till date we are governed under this only.
Now you are following this
RR.
only in Kadradi district or for all the districts?
All, Manoj.
In the same guideline, my Lord, kindly peruse the issuing authority. Kindly see the issuing authority. This is issuing authority is for only for Deputy Commissioner, Upper Siang District, Yungkyong. It's for not Karadari District. It's for not other district.
This concurrence of the Ministry of Finance, EA division, this letter, 26 June 1962, right?
Very interesting, my Lord, here, para serial number 26, here clearly given, the appropriate authority is the state government of Assam.
Because that is a NEPA, no, that point of time, that is why.
During the time of NEPA.
It has been subsequently approved. That is what we want to know, whether the state of Arunachal Pradesh have accepted this memorandum or not.
So since we FR adopted by the state, this rule should not be implemented, should not be enforced.
Whether respondent number 1 filed any affidavit?
We respondent number 2 have filed.
That's the Deputy Commissioner.
Yes, Manoj.
No, 1.
No.
Okay. Petitioners hearing. We're working as auxiliary labor corps within Beckett ALC. Under the office of the Deputy Commissioner, Kradadi District, Arunachal Pradesh. Earlier, Kradadi was in which district? Erstwhile district. Kradadi was newly created.
Kurungkame. Daden Kurungkame and
Kradadi was bifurcated from which district?
Kurungkame district.
Kurunkume.
Yes.
Erstwhile Kurunkume district. But earlier, Kurunkume was also not there earlier. Original districts were only 5.
Yes, from Lower Subansiri.
Arunachal is so vast. The petitioners claims that the post of ALC, the office of the Deputy Commissioner, are Group D posts, and they are entitled for superannuation at their 60 years. But the Deputy Commissioner, Radari District, Palin, by the impune order dated 19/04/2022,
Even without informing
sent
prior
them
notice.
on retirement with effect from 30/04/2022, as they have completed 45 years as per their service record, relying on a letter number F.47 within bracket 7 bracket close oblique NEFA NEFA oblique 57 dated 30/06/1962 of the Government of India in the Ministry of External Affairs, and letter number NI oblique 561 within bracket 14 bracket close oblique 64 dated 15/10/1965, and NI oblique 661 within bracket 14 bracket close oblique 646 dated 14/02/1965 from the Government of India and Ministry of Home Affairs, New Delhi, issued with the concurrence of the Ministry of Finance within bracket EA division, which according to the Deputy Commissioner Kradadi, response number 2, have been adopted by the state government, by the government in the state of Arunachal Pradesh. Wherein, as per which a porter oblique seeder can be retained up to the age of 45 years. Notice in this case was issued on 25/01/2023. The respondent numbers 2, who has filed and who else have filed?
2 and 3 is same. The 2 is Deputy Commissioner, 3 is EAC,
Two
who
and
issued the
three
order on
same?
behalf of.
2 and okay. It's okay. Where is that notification that FR has been adopted?
Yes,
And have you stated in your affidavit?
yes.
Where,
My
where?
additional affidavit, I have bring a report. For the RTI,
Additional affidavit you have filed on 13th of March.
12 June 2024.
Okay.
Page number 6. Annexure 1 is the RTI report. And page number 6 is the notification. Gazetted
The
notification.
petitioners by filing an additional affidavit on 15/06/2024 place the relevant instruction obtained through RTI a notification dated 20/10/2017 bearing number AR-68/2010 published in the Arunachal Pradesh Gazette on 31/10/2017 issued by the Chief Secretary of the state. Specifying that as per Fundamental Rule 56 within bracket small a, except otherwise provided in the said FR, every government servant, G capital, shall retire from service on the afternoon of the last day of the month in which he attains the age of 60 years, provided that a government servant whose date of birth is the first of a month shall retire from service on the afternoon of the last day of the preceding month on attaining the age of 60 years. It is contended by the petitioners that since they were permanent government employees, and the state of Arunachal Pradesh have followed the fundamental rules. They are supposed to retire on attaining the age of 60 years, but not on their 45 years. In view of the above, the respondent number 1, Chief Secretary of the state, shall file an affidavit clarifying the stand of the government as to whether the auxiliary labor corps serving in various districts of the state of Arunachal Pradesh, including the district of Kradadi district, including the district of Kradadi, shall retire on attaining the age of 45 years as per the service record pursuant to the notification of the Government of India issued on 30/06/1962, relied by the Deputy Commissioner Kardadi while issuing the impugn order on 19/04/2022. Or whether they shall retire on attaining the age of 60 years as per their service record. Such affidavit shall be filed by the Chief Secretary of the state on or before. We'll give you some more time so that the Chief Secretary can inquire and do the needful, because administration department has to be consulted with. Personnel and Administration Department. 30th of July. Furnishing a copy of the same in the council for the petitions. List on 5th of August. This Administration and Personnel Department. Get it.
I think, but where?
Yes, someone made a mention in the morning.
Yes, Lordship.
Yes, you wanted some time.
Lordship, I'm appearing for IMC, Lordship, on behalf of Tijama, Lordship.
What is your prayer here? What is your prayer here in this writ petition?
Your Lordship, my prayer start from page number 23, Your Lordship. Your Lordship, first thing,
Then to need not ask you, we can go to the file and get it.
Your
Right?
Lordship, to release pay, Your Lordship, monthly pending salaries, Your Lordship.
You have not been paid since October, November 2022.
Yes, Your Lord, till date, Your Lordship.
Why his salary hasn't been paid? What is the reason?
I am seated with the plan.
You are appearing for whom?
My lord, I'm appearing for respondent number 3,
Huh.
Director, Urban Local Body.
Director,
Urban Local Body.
Urban Local Body. Why the salary of the petitioner hasn't been paid?
My lord, the petitioner is under the Department of IMC, Italian Municipal Council, Commissioner Municipal Council. We are the nodal department. We transferred the salary for all the staff of IMC. It is for the IMC to decide why they are not.
Now, just tell us, how do you allot the salaries? How do you sanction these amounts, the salary component to the municipal corporations? Because IMC is you are the urban local heads, right? Body authority. And salaries are paid from the revenues earned by the municipal corporations or municipal committees, or it has been paid by the urban local body
My
authorities?
lord, as per Act of 2007 and 2019, the salary is staff of the IMC as well as the PMC. They are being paid from some who are on deputation. They are getting from their parent department, and who are being permanently absorbed, they are being given salary from the granting aid of the state.
So state grants aid.
Yes.
What is the share, 40, 60 or entire amount?
Particular.
See, there are grants in aid system is two different systems. One is that you will collect the revenues and you will deposit it in the government fund, and the government will give you 100% sanction. That is one kind of grants in aid. Other grants in aid, that every budgetary provision, the state will make certain amount for the municipal corporations, right? So that is another way of grants in aid. Sometimes it is a lump sum grant or it is a full grant. So on what procedure was adopted by the state? Now, in case of this Itanagar municipal cooperatives and the Pasighat, because it is comes under IMC. Now, in those cases, what happens? Who is paying the salary component? It is the state or your department or the IMC authorities?
It is.
Because here you see, if you come to page 36, the petitioner's name, you will get it at page number 36, serial number 1.
Yes.
He is the municipal executive engineer for Itanagar Municipal Corporation or Committee, whatever, IMC, right? And he was holding a post of deputy director. What is it?
UD, Urban Development and Housing. Type could be in page number
UD,
37.
Urban Development and Housing, functional. And he was holding that post under Department of Town Planning and Urban Local Bodies, right? Page number 36, or you can go at page number 37. Read petition. You have it?
Yes.
Now, he was Department of Town Planning and Urban Local Bodies absorbed his service. That you can see at page 39. Annexer Roman 4. And there you will see his condition of service shall be governed by the relevant rules, regulation of the government of Arunachal Pradesh, not of the Itanagar Municipal Committee or Council, and has the approval of the competent authority.
Actually, my lord, this particular order, absorption order, permanent absorption order, has been cancelled by, was cancelled. Now, it was disputed fact whether the present petitioner was, whether permanently absorbed in the Department of ULB and TP. That was the, that gave rise to so many writ petitions.
Okay. Now, is it denied by the Town Planning and Urban Local Bodies that the petitioner was not serving in that department?
Yes, my lord, his permanent absorption.
Accepting the permanent absorption in the particular Town Planning and Urban Local Bodies, it has been denied by the said department that the petitioner did not serve in that department.
My lord.
Whether petitioner served under Town Planning and Urban Local Bodies prior to his attachment with the Itanagar Municipal Council or
At
not.
the moment the absorption order was cancelled, the petitioner was basically a staff of UD and Housing. But their own deputation, he was serving under the Department of EP and ULB.
Serving under?
Town Planning and ULB.
Okay.
So earlier he was functionally that Deputy Director UD and Housing. So meaning thereby, if after cancellation of his permanent absorption by order dated
Please come to page number 45. Kindly read.
May I read?
Yes.
The Sadar Taran, Assistant Engineer, Department of Urban Development and Housing, was deputed to Itanagar Municipal Corporation. The Itanagar Municipal Council under the Department of Town Planning and Urban Local Bodies as Municipal Executive Engineer by order so and so dated 15 July 2016. The government of Uttar Pradesh created two posts of Municipal Executive Engineer under the Department of Town Planning and Urban Local Bodies by government order so and so dated 27 September 2018. It is pertinent to mention here that the approval of competitive authority was according to the jobs with other municipal executive engineer civil under Department of Town Planning and Urban Local Bodies against one existing vacant post created by order number so and so dated 27 September 2018. On the condition that the ex post facto approval from the cabinet would be obtained at
Later stage.
later stage. Yes. So, dated so and so was issued by the Department of Economic Secretary as Municipal Executive Engineer under Department of TP and ULP. Whereas the said order of adjustment and promotion of Sri Sadar Taran has been issued without following the due procedure and it was otherwise of the relevant rules. The said order has not mentioned about the condition of obtaining ex post facto approval from the cabinet at later stage as approved by the competent authority. And whereas the department has not obtained any such ex post facto approval of the cabinet so far, such promotion can be made only on the recommendation of the DPC meeting conducted by an appropriate authority, and such DPC has never been conducted by the department. Now, therefore, so Secretary Government of Uttar Pradesh, the Department of UD and Housing, Company Urban Local Body in exercise so review the said order as ab initio void and therefore cancels within immediate effect. This was the cancellation order.
Okay, that means if this order has been cancelled in May 2022, he will continue to be as what? He will continue as what?
Petitioner still on deputation under TP and ULB. From in that case, the petitioner has to obtain a draw salary from the parent department. That was the case. So, my lord, in any case, there are so many connected writ petition in this.
That or not, then who will pay petitioner's salary? With the knowledge of the respondent authorities, petitioner is serving in the Itanagar Municipal Council.
Against this very order, page 45, the petitioner has come before this court also. So we have challenged this order.
Yes.
In another petition.
It was stayed. That order of the authorities of the 11/5/2022 has been stayed by the court.
Yes.
Right. Then what happened?
My lord,
It's still pending.
still pending this that particular writ
It's still
petition.
pending. Not only 1, 2, 3 writ petitions are there.
No, only 2 posts have been created. So there cannot be numbers of writ petition. There has to be only 2 petitions. By that letter of 11/5/2022, it is very clear. Only 2 posts of municipal executive engineer has been created, where the petitioner is allowed to serve as the municipal executive engineer, civil. Right? So there has to be this writ petition and maybe another writ petition against those 2 posts. Then
Another person was given executive engineer, so against.
now, please, this is the order which you want to show, page 50. After this order was stayed by the court, way back on 26th of August 2022. Now see this order, 19 January 2024. Petitioner has been considered as executive engineer, director of urban local bodies.
Yes. No, give us some time. All of us will take instruction.
But how will he survive if salary is not paid to him?
Understood, process.
Now, just another issue, he has been transferred. Did he join or not?
He is already joined.
Join.
When did you join? You joined at Pasigat.
12/2/2024.
Yes, we have joined on 12th of February. Taking over charges there.
Yes.
So why is salary not to be paid?
Without instruction right now, we can't say anything, but
True.
initially this matter was for salary also, this was, petition was moved to stay the order of the SDO, wherein Lordship, the petitioner has taken loan from the bank and the bank is now trying to take his this one, house. Lordship.
Definitely, he has not been paid salary because the bank granted him that loan as per his salary statement.
Yes.
Now, if he's not been paid his salary, is it the fault of the petitioner for which salary has not been paid to him? Or it is because of the non-functioning of the administration he has not been paid his salary? Person
Yes.
in the air, after his rendering service, you are bound to pay him salary. Has he been illegally doing it? You throw him out. He is not entitled for salary unless he is appointed or posted in a substantive post. That's what you have to say, whether it is a substantive post or not.
So I'll take instructions and for one secretary, commissioner, urban affairs and urban affairs.
Now, petitioner is an employee of which department? As per the order of his transfer and posting, he is
IMC.
he is an employee of the urban affairs.
Urban affairs, Lordship, of course.
Urban affair comes under which department? Urban affairs government department.
Yes.
So under you only.
Yes, sir.
Then give us a date by which time you will pay his salary, at least the current salary.
Lordship.
Give us the instruction by Thursday. Because you see, this petition is pending and since long there is a stay order.
It is new petition. This particular petition.
In the earlier petition, was there any prayer for release of his salary?
Loan, Lordship. And then this bank loan was stayed, Lordship, that physical operation of this house was stayed by this honorable court on 3/5/24, Lordship. And today is second time on it. So, Lordship, I pray
Or-
that this matter
And
will
counsel for the
come up
petitioner.
after petition.
You are Mr.
Aibam, Your Lordship. My name is not there in the policy, Your Lordship. I'm appearing on behalf of RSIK, Your Lordship.
At least let us know your name first.
Yeah, Your Lordship, I am Idak Bam, Your Lordship.
On behalf of Mr. R. Saikya, counsel for the petitioner. Also heard Miss Z. Additional Advocate General or Government Advocate?
Yes, okay.
Put her name. For the response number 1.
For one, and 5, Lordship.
1 and 5.
Yes.
Who is appearing for 2, 3, 4?
Lordship, I have for 4.
You are representing whom?
Respondent number 3.
Who is for 2 urban local bodies? I think,
Lordship,
okay,
Lordship, there
1
are
and
the
2, because you will
council-
represent state. 1 and 2 will
Yes,
be
1,
1, 2 and 5. Even for 3, oh, that is Itanagar Municipal Corporation.
Yes.
Put his name for response number 3. Your good name?
T. Omo.
You. Your good name, sir,
K. Tabang, Lordship.
for IMC?
Lordship.
During the deliberation of the matter, it has come out that the petitioner is an employee in the Directorate of Urban Local Bodies under the Department of Urban Affairs, Government of Arunachal Pradesh. And presently he is serving as an executive engineer in the Pasighat Municipal Council with effect from 12/02/2024, pursuant to the order of his transfer dated 19/01/2024, issued by the Commissioner, Urban Affairs, Government of Arunachal Pradesh. And the petitioner hasn't been paid his salary from October, November 2022. Till date, including his current salary. In the meanwhile, where is that impugned order? The petitioner obtained a loan from the Bank of Baroda, Itanagar,
That has been stated on the record by the supervisor. The order of the SBM.
and for non-payment of the installments, public loan amount. The bank concerned through the Sub-Divisional Officer, Papumpare District, Doimukh, contemplated to take physical possession of the land and building of the petitioner. Where is your building and land? Which place? Your land and building at which place? Not at Pasighat. Where is it?
Doimugil.
Huh?
Doimugil.
Give us the Doimukh is a big area. Which area?
Tik Doimugil.
Where is your scheduled land? Where is your scheduled land?
Schedule is not mentioned here.
You have not given the schedule.
If you notice page number 65, it is mentioned only location of building and its premises for physical possession.
Where is it? Located at Tigdo village, Tigdo. In the Doimukh.
Yes, Your Lordship, Doimugil.
Of Papumpare district. Notice in this case was issued on 03/05/2024. And the respondents are yet to file their affidavits. Until further order, before that you write. For proper adjudication of this case, the court found that it's not Bank of Baroda, it's a Vijaya Bank. How many bank accounts from whom we have taken loan? Vijaya Bank or Bank of Baroda? Cannot we see this annexer at page 62? This is Vijaya Bank.
Last time I objected, then even the bank is not a party here.
No, we'll direct, we'll direct.
Merge हो गई है, I think you'll also this bank has been merged together, Vijay Bank and Baroda Bank. I'm not sure about it, but
Okay.
one name.
The erstwhile Vijaya Bank, now merged with the Bank of Baroda, Itanagar branch. Arunachal Pradesh is a necessary party for proper adjudication of this petition. Accordingly, petitioner is directed to make the Bank of Baroda as well as the branch manager of Bank of Baroda, Itanagar branch, a party respondents in the present proceeding as respondent numbers 6 and 7. The same shall be made by the petitioner by tomorrow. And the registry shall accordingly incorporate such and such as party respondent number 6, and we're correcting the cost title. Petitioner shall take steps for service of notice on the newly implemented respondent number 6 and 7 by registered post with heading on or before 27/06/2024. Further, the petitioner is also allowed to take steps on the respondent number 7, branch manager, Bank of Baroda, Itanagar branch, Arunachal Pradesh, by dusty oblique personnel service to be routed to the registry of this court. Such dusty oblique personnel service on the respondent number 7 shall be made by the petitioner, obtaining signature of the branch manager with date and seal, branch manager of the said bank with date and seal in presence of one or more witnesses. Thereafter, petitioner shall file an affidavit towards completion of such dusty oblique personal service on the said respondent number 7. In the interim, as passed earlier, until further order, coercive action shall not be taken against the petitioner pertaining to physical possession of his land and building at village, located at village Tigdo, Nidoimuk, Papumpara district. Okay. Subject to taking steps on the newly implemented respondent number 6 and 7.
Hello.
No representation on behalf of the petitioners at call. She's not here today. She's here. What happened, ma'am? (31). You were there for the petitioner or for the respondent?
I'm for the petitioner, Your Lordship.
Yes, I think appearing for deputy commissioner, who appeared? Miss Sate, you are appearing, I think so. I think you are appearing. See, what happened, there was an objection raised by the petitioner before the deputy commissioner. Respondent number 2. Against the issuance of the LPC in favor of his estranged wife, respondent number 4. The deputy commissioner Itanagar directed the DLR to make an inquiry and to submit a report. The LRSO, it is here. Okay. The respondent number 3 made an inquiry. Petitioner was notice was issued to the petitioner. He did not appear, but his sons appeared.
Yes, Your Lordship.
And he did not appear after receipt of the notice. So that amounts to appearance. And now, after hearing the petitioner's estranged wife and then his 2 sons and going to the records, proposed a matter in favor of the respondent number 4 that the LPC was rightly issued in favor of the respondent number 4. But matter pending before the deputy commissioner Itanagar for a long period. So the respondent number 4, after obtaining an order in a criminal petition from this court, approached the deputy commissioner saying that an order has been passed by the court. The dispute is purely civil in nature. So dispose of the particular matter relating to issuance of LPC in her favor. So accordingly, deputy commissioner have passed the impugned order in favor of the respondent number 4 pertaining to issuance of the LPC in her. So that order, while passed by the deputy commissioner, the petitioner alleged that he did not hear him. He did not give, he was not heard. That was his claim. Now, there's an old judgment of the Honorable Apex Court. While issuing an LPC, it is issued by whom? By the deputy commissioner. He is the authority concerned. That power is not delegated to any other else.
Getting NOC from.
Right. All the authorities, it is the deputy commissioner. For cancellation of an LPC, it is again the issuing authority.
Yes.
Or the authorities above him. So it is the deputy commissioner who is supposed to cancel the LPC.
Yes.
But to ease out the issues, the deputy commissioner directed the DLRSO respondent number 3 to make an inquiry and to submit the report, because the deputy commissioner have any time to make all such inquiries. But while passing the final order, the petitioner should have been heard. Right?
Yes, Your Lordship.
And the apex court in that circumstances say that hearing when the matters, say for example, at my point of time, you'll see the court passes an order allowing the secretary to consider a representation of a particular petitioner or an applicant or an incumbent after giving an opportunity of hearing. So the secretary or the commissioner, what he will do? He will ask the director to submit a report. The director will hear the incumbent other authorities, the other respondents, whoever disputed issues. So after that, he will submit a report. And the director, the secretary or the commissioner, on the basis of the report of the director, hearing the parties will pass the order. If that order is passed by the secretary without hearing the petitioner, automatically it will be in violation of the law. Similarly here, that is why the Supreme Court, in a particular judgment, today I do not have the judgment with me, have clarified that it's to be heard by the authority concerned only, not by any others. He cannot delegate to others regarding that hearing. But only one thing is very clearly mentioned by the petitioner here. Just a minute. There is a particular. The petitioner earlier filed a complaint before the deputy commissioner, which not been annexed in this petition, but it was annexed.
It has been annexed, Your Lordship.
This annexer is a part of the affidavit of the
Annexed.
number 2 and 3. Please come to page number 21. Mr. Te, we will come to page number 21 of the affidavit file. In 2020, the petitioner filed an affidavit complaint before the deputy commissioner. What it? Annexer Roman 7. Your affidavit. Affidavit of the deputy commissioner and dear also filed on 27th May 2024. Page number 21.
Yes.
Read para 2.
That although I am the actual purchaser and owner of the site and I being a government employee prefer to get payment slip, money receipt, etc. in the name of Mary Riba since she used to be my wife at that time, but no sale deed or gift deed as such was executed against the land purchased by me. Of late, I came to know that the sale deed and gift deed were executed between Sri Seda Raju Seller and Srimati Mary Riba without my knowledge and consent. It may kindly be noted that all payment, money received, etc. were done in the name of Srimati Mary C. Ori.
So it is clear that everything is in her name,
Of course, sir.
right?
Yes.
So this is one part that has the clear indication. He might have purchased, but it was purchased in the name of his wife. This is a clear admission. Then there is another part. We also call for the records of the criminal case. Now, in the criminal matter that relates to the FIR filed by the petitioner against the respondent number 4, his estranged wife, where the FIR was set aside.
Lordship, here maybe the petitioner have paid the money, but then who, in whose name it is, the document will, Lordship,
Yes,
record and documentation is.
anyway. The
That's why-
finding of the court was that dispute is civil dispute. That is why the FIR was set aside by the court,
Yes,
because it relates to property
yes.
in the name of his wife. Now, since the deputy commissioner has not heard the petitioner, obtained a report from DLRSO, no problem. On acting on that, the deputy commissioner is required to dispose of the.
Pass the order, Lordship. Yeah, yes, Lordship.
So what will you do? We'll send back the matter to the deputy commissioner
Lordship.
and he'll give a date. We'll also clarify one thing. If you come to page number. For such inquiry, the DLRSO issued notice to the petitioner. That is
Yes.
available at, he was there. It is here. It has been a part of your annexer. Page number
12, Lordship.
13.
Yes. 13 is the attendance sheet.
Page number 15. Right?
Lordship, DLRSO here in the sense, Lordship, DLRSO will do the
Inquiry.
verification and all, because he's the district land advisory, settlement officer. Lordship.
So page number 12 of your affidavit.
Yes,
Notice was issued to him, to the petitioner,
yes,
for his appearance on 29 January.
yes.
On 29 January, you come to page number 15.
Lordship.
He was there, he signed. Page number 15. Right? Thereafter, the DLRSO has submitted the report. Now, the report itself is there. Please come to the last line at page 26 of your affidavit.
Yes, Lordship.
He has submitted his report. Last paragraph, read.
Therefore, the complainant prior in his representation dated 16/10/2020, 27/10/2024, cancellation of LPC by so and so, dated 27/8/2020, issued in favor of Miss Mary River, respondent is not convincing and the documents produced are insufficient to justify his claim over the land. Submitted for perusal and passed appropriate. Yes.
That is was pending because he made the inquiry and submitted the report before the deputy commissioner.
Yes.
And deputy commissioner should have passed the order after hearing the petitioner and the respondent number 4. But what the the deputy commissioner has done, come
Yes,
to
sir.
page number 20 on. He, because of the application filed by the respondent number 4 at page 27, after the order passed by the court in the criminal petition, she approached the deputy commissioner and the deputy commissioner the matter it was pending since 2021
Lordship.
because this report was submitted in 2021 and it was pending before the Deputy Commissioner. So after this, the respondent number 4, he filed this order, he issued this order, but he did not hear the petitioner.
Yes, Lordship, we have said so on the third para on perusal of the case records wherein file number so and so. It is revealed in notice page number 11 and 12 that the matter was heard by the then dealer. So
it is fine, but thing is this, he required to, but this order should have
been
been, right? Okay. I'll pass an order remanding back the matter to the Deputy Commissioner
Yes,
to pass necessary order. But none appeared for the respondent number 4 or what?
service was complete or not, Lordship? I have no idea. The petitioner told me. Yes, I have
Unsub notice return. Notice return unserved.
Your Lordship may direct the respondent authority to rehead matter.
In absence of her, same thing will be happening. If the Deputy Commissioner has committed that mistake, now this court will commit that mistake in passing
Yes,
this
sir.
order in absence of her. Because notice had been served.
Yes, I have served notice upon
Where you
respondent.
have served?
Uh,
When did you serve? No, you are supposed to take step by registered post.
yes, I have taken register post as well, Your Lordship.
You have taken, but notice has written unserved. It's not a fact that you have not taken steps. Nikha, just right. From the office notes, it is seen that the notice upon the respondent number 4 return unserved.
Otherwise, Your Lordship may give a short that in meanwhile I'll
As you was not found in the given address. Petitioner is allowed to take fresh steps on the respondent number 4 by registered post with AD on or before 28/06/2024, providing which a correct and proper address with requisite postal stamps. List after 6 weeks.
may
You have to provide her a correct and proper address.
Yes, Your Lordship, but 6 weeks is too far, Your Lordship.
2 weeks will go in holiday. The last date is 28. You take steps. Only after reopening, the court will be able to issue notice. Just a minute. Our address is available in the criminal petition where you have appeared,
Yes, your lordship.
so. You are supposed to provide that address. She has given an affidavit. Her address is also available in her passport and next to the criminal petition.
I'll take this step again.
It's up to you. If you have given a wrong address. In her letter to the deputy commissioner, it is also mentioned along with her mobile number. It's up to you how you take address.
Yes, your lordship. Your lordship, I have interim prayer, your lordship.
That cannot be considered. Yes, next.
Item number 30. Please.
Yes, Mr. Mo, why it has been
In
listed
this
today?
matter, Malad, this is ejectment matter, Malad. We have taken step to respondent of 5 and service is still awaited, Malad. And respondent number 4, they have filed affidavit and our rejoinder is almost ready. We are yet to file a rejoinder, Malad.
What is the order passed in 3902-2021? Where is that order?
309 is Malad, may I please to see in.
Where is that order?
Yes, Malad. Just tackle that order, Malad.
Okay, page number 174, 173.
That execution notice was set aside, Malad, and it was sent back to the
Yes, who is appearing for the forest? You are appearing. Then please come to page number 175. How you have complied with this order?
yeah, operating person is page 75, yes.
Which order is under challenge now?
My lord, yes. The impugn order, my lord, is in page, my lord, is in page 118.
118.
118, my lord.
Of which date?
My lord, there is no date, there is no any mention of date when it was issued. Nothing is there, my lord. 118 and the type copy is in page 119, my lord. My lord, in this matter, my lord, this complaint, the DFO has issued a notice on the basis of a complaint filed by the student union, my lord. Because the petitioner, they have been doing agriculture in that area and it doesn't come under the forest area, my lord. This notice itself is a misconcept, my lord. There also order from a deputy commissioner for connecting the route to that agricultural lane. There is no any disputed by the.
Yes, how you have clarified? When did you issue notice to them?
Lordship, we have, Lordship, we have filed our affidavit. In our affidavit,
yes.
Notice, we issued press notice, Lordship.
When?
Dated 20 January 2023.
20th January 2022.
3.
Where is that? In which page you can show?
Lordship, NXR 6 series, page number 27.
Page
in our
number
affidavit
27.
Lordship.
No, that notice was never served, my lord. We have studied in our paragraph. We came to know about the impugn order when the petitioner visited the office of the divisional.
How you have served this notice?
Divisional forest officers. We have studied in the para.
How you have served this notice?
In their respective lordship address.
By post or by
through,
process server or by what?
Through RFO range forest office, he is directed to serve the notice and submit a signed copy of this order. Lordship will see in the copy to file.
Now, where from you are going to show that they have received notice from the RFO? Do you have anything to show that notice have been duly served on them? See, and processors will always try to take various pleas. Now here is a plea that they have not received notice. How you have established that you have received notice?
Well, in this matter, our case is.
We'll come to that. You are saying it's not a land under forest. That will come later. Have you taken their attendance when they appeared before the hearing in the office of the DFO?
Lordship is at Annexure 5, page 24, Lordship.
Page 24.
Lordship. Page 24 is the hearing and persons who were here have 25, Lordship.
Have you obtained?
Of course, Lordship.
How will you clarify?
But the record established that they were present if the official record.
That is, unless you have the attendance, you have not taken their attendance, how will you say that they appeared? Will you be able to show that the petitioners received the notices as been issued to them through the range forest officer? Will you be able to place the register?
Lordship, we can try for this conduction of hearing, Lordship. That page 25 part, Lordship.
Say, two options are there before you. Whether you will to show before the court that you have duly issued the notices upon the petitioner on the basis of records.
Lordship.
That means while serving the notice, as you have stated, that the RFO is required to obtain signatures, right? And submit a signed copy of this office. Further, a copy of the notice shall also be affixed on the outer doors of the building necessary by Riba Amri, right? So have you complied with that provision or not? That has to be done. First, you have to show it from the records. Secondly, the persons who appeared. See, if you have affixed the notice in their houses outside their houses or outside their premises. You should have obtained a photograph, mobile, place it before the DFO. That is enough proof. Have you done it? Number one. Number two, whether the petitioners appeared before the DFO, you have obtained their signatures or not. This is first. If you have these things on your record, well and good. If you do not have, option is very clear. Petitioners are now aware of this notice, ejectment notice. You will give them a date. They will file their objections, if any. Then
That would be better.
you take instruction from your concerned DFO of Dibang Forest Division and tell us Wednesday. Get it and get it on record. That means he will send it to any communication through you in writing. So as the thing in your WhatsApp, that will also be enough. But you should, if you cannot say that DFO is not certain, then we'll pass the order, we'll give them a date, and they will accordingly appear before the DA. That is up to you. Number two, regarding the dispute that land is a forest land and not, who will decide? Who will decide? Land Settlement Authority will decide.
Yes.
Now, Land Settlement Authority will decide. Now, the Deputy Commissioner of Dibang Valley will decide from the land records.
Yes.
Now, where is the notification? It's a forest land.
Lordship, it is in
Page number, sometimes you say that day. And process will always go and say that this is not a forest land, this is habitable land, many things will come. Where from you are saying that this is a forest land?
Lordship, it's
And
in
there are
Annexer 8 series, Lordship.
Annexer 8 series of your petition.
Lordship. Now type copy is at page 55.
8 series, which page can you tell us?
55, Lordship.
Huh?
Annexer 8 series, page 54, and type copy is at 55, Lordship. Clear copy is.
Okay. Now, any area has been de-reserved,
Yes, my lord.
so as the notification.
That is
So-
annexed in page 60.
Page
60.
of your read petition,
No, in the counter affidavit.
page 60,
Yes, sir.
denotified.
Yes.
You are in occupation of this.
No, I am basically my
No,
area
no, no.
is.
Are you in occupation of this de-reserved land?
No, no, my lord.
Okay. Now, whether this notification has been published in the Gazette or not?
Lordship,
De-reserved forest land has been published in the Gazette notification or not? Unless it is published in the Gazette, there will not be any de-reservation. You cannot do that. You are not prepared with the case. Why? It's your case. There's a stay order in force. You should be fully prepared. It's already 4:50. If you are go on reading now, nothing will happen. Whether this land in occupation of the petitioners are in de-reserved land or within the forest land.
Lordship, if it is under the reserve, then we should not have given the eviction.
That is apparently, but thing is this, that clarification has to be there. That it is in the forest land. Now, if it is in the forest land, have you served them notice properly or not? In terms of the order of the court. Right? That is what we want to know from you. You tell us on Wednesday. List on. What's your good name?
I did not.
I heard Mr. asked me for the petitioner. And petitioners. and such list on 26, enabling the respondent number 2, 4, 2 and 4 to apprise the court whether the notices ejection notice under section 3 within bracket 3 within bracket small Roman 1 of the Arunachal Pradesh Forest bracket close ejectment of unauthorized persons from reserve forests bracket close rules 2013 issued on 20/01/2023 through the range forest officer rowing range have been duly served upon the petitioners or not, obtaining necessary proof of that. Further, the DFO, Dibang Forest Division, shall also apprise the court as to whether any attendance of the encroachers appeared during the hearing on 31/01/2022 have been obtained by him on while passing the impugn ejectment order. That's it. Do it day after tomorrow.
My lordship, Thursday.
Thursday. Okay, on Thursday. Fine. 27th. Any further? Any item? 10 more.
My lord, interim is there, my lord, interim can.
All will go after vacation.
My lord, interim will continue.
So bring it to the, we'll pass it. Whatever is interim, we'll extend it to next after vacation.